Okay.
All right, I'll give him another minute, and if he's not on, I'll just start it. I think Steve's in the waiting room.
You're absolutely right. Sorry.
Good morning. I'd like to call to order this meeting for Thursday, the 8th of April of the Judiciary Committee. Members are still in caucus, so we're going to recess. I want to just, before we do that, check with my co-chair and see if there's anything he has to say before we go into recess. For the members, you will get notification when all of the caucuses have finished and any of the discussions pursuant to that have happened about the time that we will reconvene. With that, we'll stand in recess. Thank you very much. Is Steve on? Oh, there he is. We ready to go, Madam Administrator? Okay.
Can't hear
So,
me. Yes.
all right. So I would like to reconvene this meeting of the Judiciary Committee for Thursday, April 8th, 2021. Any comments from my co-chair or the ranking member?
No, sir. Thank you.
Don't see any, so let's move into the agenda. Roman numeral number 3. We will go to item number 2, which is Senate Bill 940, an act concerning state agency compliance with probate court orders. Is there a motion?
Motion made.
Is there a second?
Second.
I missed who the second. Was that you, Senator Champagne?
Yes.
So motion made by Representative Fishbein, a second by Senator Champagne. Representative Stafford? No?
Representative Blumenthal.
Oh, I'm sorry. That's right. Representative Blumenthal.
Thank you, Mr. Chair. This bill is a relatively simple one. It essentially makes clear what it should be already existing law, which is that when a probate court issues an order binding a state agency, that order actually binds the state agency. It does not expand the jurisdiction of the probate court, but merely clarifies the controlling nature of probate court decisions on state agencies.
Thank you, Representative. Is there a comment or a question from members of the committee? Is there a comment or a question from members of the committee? I don't have my list in front of me. Are we voting a roll call on this? Okay. Madam Administrator, when you are ready, please call the roll.
And that was the motion for a JF. That was Senate Bill 940. Senator Winfield,
Senator Winfield in the affirmative.
Representative Staffstrom,
Representative Staffstrom in the affirmative.
Senator Kasser.
Senator Kasser votes yes.
Can you please repeat?
I'm sorry. Senator Kasser votes yes.
Thank you. Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel, Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry. Representative Dillon. Representative DeMassa.
Representative DeMassa votes yes.
Representative DeMassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Can you please repeat, Representative Doucette?
Representative Doucette votes yes.
Thank you. Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes yes.
Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Yes, Representative Godfrey votes yes.
Right out of the gate. Perfect. Representative
Yay.
Godfrey has Representative Harding. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola. Senator Lesser. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak D'Amato. Pavlak D'Amato votes yes. Representative Pavlak D'Amato has voted yes. Representative Porter. Representative Quinn. Representative Rabimbus.
Representative Rabimbus votes yes.
Could you please repeat?
Representative Rabimbus votes yes.
Representative Rabimbus has voted yes. Thank you. Representative Riley.
Representative Riley votes yes.
Thank you, Representative Riley. Senator Sampson. Representative Sims.
Representative Sims in the affirmative.
Could you please repeat, Representative Sims?
Representative Sims in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative. Representative Young.
Representative Young votes yes.
Representative Young has voted yes. And I know Representative
Senator
Quinn.
Anwar
Oh,
votes
Senator.
yes. Sorry for being.
Senator. Okay, Senator Anwar has voted yes.
Representative Labriola votes yes.
Representative Labriola has voted yes.
And Representative Quinn votes yes.
Representative Quinn has voted yes. Thank you.
Thank you, Madam Administrator. We will be holding the votes open for a while. We hadn't had a full discussion of that. So for now, I'm going to say that we'll have till 5 o'clock or a half hour after the meeting. And I'll check in with my co-chair to make sure that that's what we're doing. We will now turn to item number 3 on the agenda. And let me just get back to where I was. Item number 3 on the agenda, which is Senate Bill number 989, an act concerning online hate, online harassment. Is there a motion?
So moved.
Second.
Second.
Moved by Representative Fishbein, seconded by Representative Staffstrom. This is a bill that comes to us looking to deal with what we are seeing is an increase in online harassment. It's looking to extend the stalking crime that we have in the first degree to include hate-based actions on the part of individuals. It's looking to extend those in the second degree to include electronic instances of giving out electronic information when there is no consent, and establishing civil actions for these types of crimes. And it is looking to increase the types of forms of electronic communication that the crime of harassment in the second degree is applicable to. Comment, discussion, questions.
Excuse me, Senator Winfield, if you could clarify.
Sorry?
I just said, if you could clarify that it is a JFS, it's a substitute.
Yes, I'm sorry. It's JFS substitute LCO 6326. And just to check, Representative Fishbein, are you good to make your motion on that JFS language?
Yes, sir. Thank you.
And Representative Staffstrom, are you good to second that motion?
Yes, sir. I second the JFS.
Okay. All right. Comments, questions, discussion on the language before us? Comment, question, or discussion? Representative Fishbein, is this?
Yes, sir.
Something that we?
Mr. Chairman, I make a motion that we create a consent calendar and that we move item number 3, which is SB 989, the JFS language, to that consent calendar.
Thank you very much, Representative. Is there objection to creating this consent calendar and placing this item on the consent calendar? I do not see any. So item number 3, Senate Bill number 989 will be placed on the consent calendar. We are next going to go to item number 6, which is Senate Bill number 1091. It's an act concerning a study of criminal laws in the state, but there's JFS language. And that JFS language is LCO 6573. And it is the language that we had seen in our domestic violence bills. Is there a motion?
Motion is made by Senator Flexer.
Motion by Senator Flex. Is there a second? Second by Senator Kasser. I am going to have Senator Flexer and Kasser explain the bill. I want to thank them for the work that they put in here. This is a lot of work. It's an important work, and it's still work that we are currently in the process of doing. But Senator Flexer, who, as we know, on the committee has worked a long time on these issues, and Senator Kasser, who worked very diligently on Senate Bill 1060 and has worked on these issues as well, have brought us to this moment, and I will now throw to them to explain the JFS language.
Thank you, Mr. Chair.
Go ahead, Senator.
Thanks. I want to thank our chairs so much for bringing us to this point, and all of the advocates, Senator Flexer, Gilchrist, and others who have also been working on this issue for many years and done so many good things for victims of domestic violence. This is really the product of many people's input and expertise and life experience. And I also want to particularly thank Representative Porter for sharing her personal experiences during the public hearing, where we heard from literally dozens and dozens of survivors about the need for change in our system. So what this bill does, and I think it really is critical legislation and groundbreaking in many ways, is it creates a uniform definition of domestic violence for our family law statutes, which did not exist before. And it recognizes that much of domestic violence is not physical. And those non-physical forms of violence can often be more damaging and devastating and destructive than physical, and they are predictors of physical violence. So this definition is not meant to be restrictive. It's meant to be illustrative of what coercive control can look like, but certainly there are other forms as well that are not particularly delineated here. It's meant to be a tool for judges to recognize domestic violence and to continue to use their discretion to penalize it. I will just speak about the sections of the bill that I was involved with, and then yield to Senator Flexer. But I just want to make note that this definition of domestic violence, including coercive control, is now also specifically referenced in the custody statute, which is unfortunately where domestic violence often plays out. There is also a section that requires victims to be informed of their rights to participate in court proceedings remotely, so that they don't have to appear physically in person in the courthouse next to their abuser. And there is also a section that attempts to create a standard for vexatious litigation, which is another commonly used technique by abusers. And I'll pause there and yield to Senator Flexer.
Thank you. Thank you, Senator Kasser. And I too want to thank you, and I want to thank the leadership of this committee for placing an emphasis on this issue and recognizing how important it is that Connecticut have as strong laws and policy as possible to make sure that our systems are protecting victims of domestic violence and making it clear that domestic violence in all forms are unacceptable in our society. And I think what we have before us today is a really important piece of legislation that I'm hopeful the broad membership of this committee will choose to support. I'm going to go through all of the sections just so that everyone has a full understanding of exactly what's in here, especially given that this is a new bill number. Again, it's LCO number 6573 for members of the committee that may want to follow along. As Senator Kasser referenced, the first section has to do with including the definition of coercive control in the definition of domestic violence in 46B-1. Section 2 also incorporates the definition of coercive control into the family violence restraining order statutes. That's 46B-15. And it also continues the current practice of allowing victims to be able to file a statement under penalty of false statement instead of a notarized statement in order to access the protection of a restraining order. That's a key reform that has been brought forward because of the pandemic and has provided a different level of access to our court systems for victims of domestic violence. And this new definition within the restraining order statute, I think, is really important. For a long time, been working to try to make sure that 46B-15 was as inclusive as possible, so victims that are presenting themselves to the family court seeking relief, trying to break themselves away from an abusive situation, that they could find a court that would acknowledge the abuse that's happening and give them the protection of a restraining order. And I'd be remiss if I didn't at this moment reference the great work of our ranking member's predecessor, God rest her soul, Representative Mary Fritz, who worked really hard on this statute in the past, 46B-15, and I think she'd be proud to see what we've done here today, given all the great work she did in her service in the legislature to try to protect victims of domestic violence. Section 3 also requires notification to survivors that they can testify, that they don't have to be physically present, as Senator Kasser referenced. Section 4 specifies that violations of court orders issued for family violence will be considered a family crime. One of the issues that victims have had many times is that simply violating a restraining order has not qualified as a family violence crime. And therefore, it's not treated with the seriousness that we would like a family violence crime to be treated, and making sure that that violation is not just technical in nature, but it is in fact a criminal violation of the family violence statute. And I think this is a really key reform. Section 5 ensures that victims of domestic violence who are trying to use the federal protection of U visas, that is available to them no matter what happens with the criminal case that they are a part of, that as long as they were attempting to help municipal or state law enforcement, that they would qualify for the protection of a U visa. Section 6 requires that notification happens to survivors, that they can testify remotely again, and that they don't have to do it in the presence of the abuser. Section 7 adds a new best interest factor in the now 16, soon to be 17 portions of our divorce and custody statutes. Section 8 does the same thing. It adds that the physical and emotional safety of the child needs to be considered in those 17 delineations of best interest. And it also makes reference, as Senator Kasser said, to the existing definition of domestic violence in 46B-1. Section 9 is the language that Senator Kasser referenced about frivolous or intentionally fabricated proceedings or motions. Section 10 is an effort, again, something this committee's been working on for quite some time, to ensure that victims have space in our courthouses. There's been an issue for quite some time where previously victim advocates would have to meet with domestic violence victims in the lobby areas or other public areas of our courthouses. The judicial branch has done great work in cooperation with CCADV and this committee over the last many years to try to make sure that there are more space for private meetings for victim advocates and victims, and this section would continue to advance that effort. Section 11 requires that if there's a request that a family violence victim advocate be able to be in criminal court and that they be provided with the arrest report. Sections 12 through 14 deal with allowing victims who are trying to leave an abusive situation but whose current income requirements would prohibit them from being able to access programs that might financially allow them to make the choice to leave an abusive situation. This is similar to language that came out of the Human Services Committee that I believe was unanimous in that committee. Sections 15 through 17 have to do with insurance policies and making sure that a person who is a victim of domestic violence is not discriminated against. Section 18 and 19 has to do with the Civil Gideon program for survivors of domestic violence who are trying to apply for restraining orders. This builds on the great work that this committee has done over the last several years to try to expand access to legal representation, and the great work of Senator Looney, particularly on this issue. Section 20 has to do with the violation of court orders for family violence, and it highlights the increased risk that such violations pose when there is family violence present, and that the court should consider that, especially when they are determining cash bond. And sections 21 through 23 include reforms to our state's hate crime statutes and strengthen those statutes. So that is I think a pretty thorough summary of what this bill does. Again, I think this is a really strong piece of legislation that we can all be proud of, that represents the diligent work of a lot of really good people trying to come to consensus. As Senator Kasser mentioned, several members of this committee and of the House and the Senate who've been working on these issues for several years, and particularly on these pieces of legislation over the last several months. And I do just want to thank the folks, who work with these victims day in and day out, who came and were a part of crafting the legislation to get it where we are here today. These folks are helping victims at their most vulnerable moment. They're on the front lines. They see how challenging the individual circumstances are for so many people, and this legislation is going to give both victim advocates and victims themselves the tools they need to protect each other, to protect themselves. And I really want to thank the Connecticut Coalition Against Domestic Violence. That agency has a history of coming to this committee, working with people on various sides of issues, bills, so that we can have pieces of legislation that become law that we can all be proud of, and where every stakeholder felt like they were heard at the table. And I'm really grateful to the coalition for their leadership. I want to just make sure that all victims know that if you need help, you can go to their member agency. CCADV has 18 corner of the state, and if you are in an abusive situation, you're not sure where to turn, and you're not sure where to go, the Connecticut Coalition Against Domestic Violence and their member agencies are to help you, and they will help you navigate and find a way to get out of an abusive relationship and find a path to safety for yourself and for your family. So thank you very much, Mr. Chair, for your efforts on this legislation, and thank you for the opportunity to summarize this bill that's before us today, that I think is something we can be proud of.
Thank you, Senator Flexer. Thank you, Senator Kasser. Comment or question from members of the committee? Comment or question, Representative Fishbach.
Thank you, Mr. Chairman. Mr. Chairman, I will recognize that there are some good things in this bill, but there's some troubling things in this bill as well. And I just had some questions. I'll ask the question. You can, if you know, or you want to send me somewhere, that's fine.
I'm going to ask the two proponents to attempt to answer the question, and if not, we'll try to get you an answer. Proceed, Representative.
Thank you very much, sir. I'm looking at line 42, where it deals with, talks about coercive control, and it has that qualifier, unreasonably engaging in. And who is to determine the unreasonableness that gives the gatekeeper function to the filing of the action? Through you, Mr. Chair.
Thank you, Representative. Senator Flexer Kasser.
I'll take that. Thanks. Thank you. Through you, Mr. Chair. Unreasonably engaging in any of the following activities was used because it is conceivable that someone could engage in some of those activities on an infrequent basis, maybe once or twice, and it is in a reasonable context. So if you're asking who determines what is reasonable, ultimately the judge would determine. This would still all be in the discretion of a judge to determine what is reasonable or unreasonable. But without that qualifier there, it is conceivable that somebody who's actually an abuser could cite one specific instance or maybe a few instances and cast themselves as the victim. So we inserted that language. It's used in other states as well to be a qualifier.
What other states use this language?
California.
You said states, that would be plural. What other states?
Oh, I'm sorry. California uses.
Okay, so one other state. And when did they put that into place?
I'm sorry, your question was?
Yes, when did they put that into place?
Their bill was passed in late 2020. I'm not sure the exact date.
Okay, so the actual effectiveness of that, you would agree, is untested?
Yes, but I would say that without that qualifier there, if we just say anybody who's engaged in any of the following activities ever, you could get some very strange outcomes in which we wouldn't want to have. For instance, isolating a household member from friends or relatives. One could argue that if a person said to their spouse, I don't want you to visit your brother this weekend, that was isolating them, but that's a reasonable request. So we're looking for patterns of unreasonable actions that fall under these categories, not reasonable actions that fall under these categories.
Okay, and in your scenario that you just gave about, I don't want you to visit your brother, I would expect that the punchline to that is or else, right? Or else I am going to do something. Is that what makes that objectionable or not objectionable? I'm just trying to figure out, merely saying I don't want you to visit your brother, there has to be some sort of perceived or actual consequence to going to visit the brother, correct? And I'm just trying, in your scenario, what is that perceived or actual consequence?
Well, exactly. If there is a consequence that is unreasonable, then that would qualify as an act of isolation. So I can't tell you what somebody might say, but if there is a pattern, again, this all refers back to a pattern of unreasonable behavior in these following categories, but not limited to these categories. It's very important to understand this is not an exhaustive list of actions that rise to the level of coercive control. It's merely meant to be an illustrative list.
Yes.
So that judges can begin to recognize, and judges already do recognize these behaviors. That's what they have told us. They recognize the behaviors. They just don't have the tools in the law as it's currently written to protect victims, because the law is currently written, as you know, only recognizes physical threats physical harm, and stalking.
Well, what do you say that the current law, when we look at 46B15, which is the current law,
Mhm.
continuous threat of present physical pain or physical injury. So when we get to the punchline of the scenario, I don't want you to visit the brother, the punchline, and I've had these situations. The punchline is, or I'm going to physically abuse you in some way, shape, or form. If you go to visit your brother, that is the threat, right? That's the underlying threat. And that's what we're looking to stop here. I would suppose by this legislation. Correct?
Correct. We're looking to recognize and prevent a pattern of actions that causes a person, that deprives a person of their free will and personal liberty. That's really important. So there may be a spoken threat. There may not be a spoken threat. It may be unspoken, the consequences. So that's why, again, the qualifier of unreasonable and the qualifier that it must be a pattern of actions is in there. So it's not, sorry, continue.
No, and I'm just trying to dealing with that scenario because what's been represented to us is, and you just said that judges don't have the tools to address those concerns. Assuming that that is the case and the threat is physical violence, if the individual is going to go visit the brother, what precludes that is a form of threat, right? Don't go visit the brother, or there will be physical violence. I will do something, right? We would agree that that is already addressed under 46B15, right? That's a threat of physical violence or harm. It is not actually said. It is a legitimate perceived threat to the individual, subjective. That individual can go to court under the current statute, because I've had these cases, and allege that. I was told not to go visit my brother, or if I do, I am fearful that my husband will strike me in that particular case. And this is the reason why. The current law addresses that. So I'm trying to figure out in this scenario of do not visit the brother, or what is the punchline that is not currently addressed that we need this language? Can you give me a punchline?
Yes.
That is not. Yes, sure.
So, but the scenario you painted, don't go visit your brother or else you will be harmed. That is a direct threat of physical harm. That is not what this is trying to capture. This is trying to capture indirect, unspoken threats. So, and consequences, not just threats, but consequences. So a pattern of isolating a household or family member from friends, relatives, or other sources of support looks like a person who has been cut off from their family members, relatives, friends, maybe told they can't see a therapist, they cannot get the forms of support that one should be able to access if one had free will and liberty. So it can be something that happens over the course of years or over the course of months. It could look like, somebody telling their girlfriend, I don't like your friends. I don't want you to see them. I don't like your parents. I don't want to go visit them. I don't want you to go visit them. There may not be a threat of violence, but the erosion of those relationships is a condition of the relationship with the abusive person. And that results in isolation, which is a form of coercive control.
But thank you for that. And just to be clear, in the scenario that we were discussing, there was no actual threat. It's a perceived threat. So, husband says, I don't want you to go visit your brother, and he kicks the trash can. You know, he makes some sort of overt act against something else that is not the spouse. She's fearful. She's fearful that he is going to use that rage against her. That is not an actual threat to her, but that is her subjective understanding of the situation, the consequence of her going to visit her brother. That is actionable. She can go to court under 4615. She can say, this is what he did. This is why I'm fearful. Please help me. And that's, you know, just an example of, I have some difficulty with this list. A lot of it is already addressed in our statutes, and you know, I'm going to move forward from there. But in line 102, you know, presently to make a claim of abuse rising to the level of restraint, you have to do an affidavit. But in this language, you reduce the bar on that attestation because you're taking out affidavit and you're making it a penalty under false statement, which requires police intervention should that attestation not be correct. You agree with me on the legal by reducing that bar? Through you, Mr. Chair.
Senator,
I'm going to defer to Senator Flexer on this.
Senator Flexer.
Thank you, Mr. Chair. Mr. Chair, the section that was just referenced is an attempt to codify current practice right now. So right now, since the onset of the pandemic, victims of domestic violence have been able to make applications for relief through a restraining order under penalty of false statement through the judicial branch instead of having to go physically inside of a courthouse. So yes, it is a different standard than an affidavit made under oath, but I would state that this is still a serious consequence. The penalty of false statement is still a criminal act. I believe it would be the crime of perjury if you were to make a false statement by making the application this way. So I think the seriousness of a false statement, either by an affidavit under oath or an affidavit, or excuse me, or the statement outlined in the new language, are equally as serious.
Okay, like I respectfully disagree. Even we had Judge Albus before us a few weeks ago on the court ops bill, in which there are sections of that which do exactly this, and Judge Albus agreed that you were lowering the bar, and you know, that's of concern to me. These cases are serious, and I'll tell you that through the pandemic, because of the eviction moratorium, you know, people have attempted to utilize this process to get people out of places where they live. And I had a hearing before Judge Albus not too long ago on a restraining order. And I said to the judge, you know, it's unfortunate that we're here because there are legitimate victims of domestic violence out there, and people who misuse this system for ulterior means are diminishing that fact. And here, lowering that bar just invites that. Because ultimately the penalty is required to be investigated by the police and for them to use their discretion on whether or not to arrest that individual for making use of the process improperly. And that's a lot of hurdles. So another problem.
If I may.
Yes, sir. Yes, ma'am. Sorry.
Senator Flexer.
Thank you. Representative, I hear the good representative's concerns. I would just point out that the judicial branch does support this language, and they've included it in one of their major pieces of legislation this year as well. So I think they've come down on the notion of the relief of a restraining order being more accessible to more victims of domestic violence is outweighs the potential of that the good representative just described. And I'd be happy to hear more about the concerns that have been raised, that people are making these false statements. This is the first that I am hearing of it, but I would just emphasize that the judicial did recognize that this is a different standard that's contemplated in this legislation, but they do ultimately support it.
Thank you, Mr. Chairman. That raises another question. Can either of the good representatives give me one case where any individual in the state of Connecticut has been unable to file for a restraining order because it required an affidavit?
Senator Fluxer.
At the beginning of the pandemic, there were victims who were unable to file for a restraining order in the first few weeks.
Because thank you, Mr. Chairman. Yes, the courthouses were closed. So, but when the courthouses are open, has there been any instance where anyone has been unable to file for a restraining order because of this affidavit requirement?
Senator Fluxer.
The affidavit requirement is currently not in practice. So right now, it is current practice right now because of the pandemic that victims can electronically apply for a restraining order, and the language in front of us is attempting to codify that.
Thank you, Mr. Chairman. I respect that, but 46B15 went into place many, many years ago. When I was a clerk 20 years ago, we did these, we took oaths at the window. I mean, since the very existence of the ability to file for a restraining order, has anyone been unable to file for a restraining order because of the affidavit requirement? Because I know of none, and I know there's been no complaints about that. So is there any incident?
Senator Fluxer.
Yes, through you, Mr. Chair. There were dozens of victims at the beginning of the pandemic who were unable to apply for restraining orders because of the affidavit requirement.
Okay, got it. Thank you. In lines 353 through 368, there's currently a process by which one who files for a restraining order doesn't want to, for whatever reason, appear in person in court. And this mandates that if a party says, I don't want to go to court to testify, that a court has to grant them some alternative means to testify. And my question is, well, first of all, does any other state do this? Mandate that it's going to happen? And the second question is, would be what states?
Senator Fluxer. Senator Kessler has her hand up. Senator Kessler.
Thank you, Mr. Chair. Through you, I'm not an expert on what other states are doing in terms of allowing victims remote access to court hearings, but I can tell you that in Connecticut, we passed a law in 2009 that did allow victims to participate remotely. Now, the technology that's referenced in that public act is it's a closed cable, closed circuit television, or something of that sort, which is not what we use today. We use video conference. So, and now that's become regular practice. Even though we had that law on the books for 11 years or 10 years before the pandemic, it really wasn't implemented because victims did not know that they had that right. And maybe the technology really wasn't quite ready. So now that we've gone through the pandemic, the technology has been tested, it is working well. This section that you reference is an attempt to inform victims that they have that right and they can exercise it. And we know that judicial is capable of doing these things remotely because they have been for many months now.
Representative Fishbaum.
Thank you, Mr. Chairman. With all due respect, this is not the notice provision that's elsewhere in the bill. I'm talking about specifically under the current statute 46B15C. It's permissive. It says the court may permit that to happen. What this legislation does is it doesn't take away the permissiveness. It says merely based upon the request that the court has to, so shall, permit that individual to not appear in court, testify through some other means. And my question was, what other state does this?
Senator Kasser.
Yeah, I could do research. We could do research and find out what other states have it. But it seems logical that if a person feels unsafe in the presence of another person who is under a restraining order, so has already been proven and a court has already accepted that that person presents a danger, that the applicant should have the right to participate remotely. So I can't imagine a circumstance in which there would be an overriding right by somebody else to force them to appear in person.
Well, and see, that's exactly the problem. You just said that that person has proven that they pose a danger. No, they haven't. They procedurally, all that has been before the court, which is where proof is issued, is a piece of paper. And the piece of paper has allegations on it. And a judge believes what's on the piece of paper, and the judge orders it. And under our Constitution, we have rights of due process. That due process says that you have the right to a hearing, and you have a right to defend yourself, and you have a right to present evidence and to prove what is actually the fact. But at the point that you were just talking about, you said that, why should you make that person stand next to it? It's been proven that they pose a danger. Well, that's just not true. It's not the way the process acts. And, I just referenced the Constitution. I do so again because our Constitution says that we have a right to face our accusers. So I'm not surprised, I don't think any other state does have this mandate because it's more than likely unconstitutional. And I don't come from this. I've represented plenty of women getting restraining orders and plenty of usually men. Well, no, I did represent a woman defending a restraining order on both sides. I just, that's part of the problem is the granting of an ex parte order is not proof of anything other than a document was submitted to the court and it was believed. And I truly know that many of these cases are very serious and they are truthful. The last thing I wanted to touch on before I defer to my colleagues, there's a portion of this bill that, two other things. On page 35, it's lines 181 through 188, or 1088. So 1081 through 1088. It precludes a insurance carrier from changing premiums based upon somebody being a victim of domestic violence. And I agree that would be a bad thing. But I'm trying to say, is it a solution looking for a problem? Does this happen? I mean, is there any incident that we know of where the insurance company is well, they can't see restraining orders. We know that electronically on the system under the Violence Against Women's Act. Is there an incident where an insurer adjusted premiums because someone who's allegedly a victim of domestic violence?
Well, I'll let.
That's it.
Sorry, Mr. Chair.
No, you can go ahead.
I'll let Senator Flexer answer that about that, but I just wanted to respond to your previous comments about due process and the rights of an accused person to face their accuser. And I absolutely agree. I'm not challenging that constitutional right at all, but this is how our courts have now been adjudicating cases quite successfully for many months now. And it's not that the accuser doesn't have the right any longer to face their accuser. It's that they face one another as we are facing one another now through video conference, through electronic means. So it does not abridge that right. It's simply a new forum in which that confrontation and due process takes place. And I'll yield to Senator Flexer about the insurance.
Mr. Chairman, before we get to the answer to the question, I just need to respond, and I will tell you that I believe every restraining order case that has been adjudicated in our courts since the start of the pandemic, absent one of these requests, has been in person and not by video. I think I've done 6 of them since the start of the pandemic. They've all been in person. So I just want, there's a lot of talk about what happens in our courts. I just want to correct that. So thank you, Mr. Chairman.
Senator Flexer.
Thank you, Mr. Chair. And Mr. Chair, at the risk of making the dialogue that's happening in the committee confusing, I want to echo the comments of Senator Kasser on Section 3. And while I certainly am open to accepting the feedback, particularly around the use of the word may versus shall in Section 3, I do want to emphasize that we heard testimony in the public hearing about a lot of different tragedies where people lost their lives due to domestic violence. And I'm not going to repeat the names that I'm about to reference, the case I'm about to reference, because that family has asked for privacy. So it's not out of a sign of disrespect, but that they've asked to be able to move forward with their life. But there are multiple people who have died in the state of Connecticut over the last 10 to 15 years who stood in a courtroom, and what they wrote on their affidavit, on their application for the restraining order, was crystal clear. But when they had to stand next to their abuser in front of a judge in a court setting that's very scary to most people who don't spend a lot of time in courthouses, it's completely debilitating. And so if a judge thinks it's best for that person to be able to state their piece in a place that's going to be safe for them, and that they're not going to be overwhelmed with the fear and anxiety that accompanies being a victim of domestic violence. And I think that's a huge step forward. And perhaps if that had been in place 15 years ago, there's a lot of people who've lost their lives who perhaps wouldn't have if they hadn't have had to stand 2 feet away from their known abuser in order to simply get a restraining order continued. With respect
Continue.
to the insurance statutes, there are 26 other states that have this requirement. So this is not cutting edge policy as some of the other pieces of this bill are. There have been victims who have had issues with their insurance company because they were discovered to be victims of family violence, and this legislation would just catch Connecticut up with half of the rest of the country.
Representative Fishman.
Thanks, Mr. Chairman. I'll take that. I'll look into that a little bit further. I thank you for that. I just want to make it clear, Mr. Chairman, that I certainly, I've had some clients that are not on this earth anymore, and I take this stuff very seriously. I just, when we talk colloquially about cases that we've heard about, that's one thing, but I've done quite a few of these cases. So The last section is in lines 1385 through 1393. There's money that's given to, well, essentially it comes from the judicial branch, or it comes from the AG's office, that is given to certain judicial districts for the purposes of administering programs surrounding restraining orders. Is that fair to say what 1385 through 1393 has to do with?
Senator Flexer?
Yes. So this is an expansion of giving legal representation to individuals who are seeking the relief of restraining order.
Okay. And can I ask you where in the state of Connecticut the judicial district of Bridgeport is?
Senator Flexer?
I'm not sure it's relevant to the debate on the bill, Mr. Chair, exactly where the judicial district of Bridgeport is. In the bill, it's described accurately as the judicial district of Bridgeport. And when this is implemented, the judicial district of Bridgeport will do it regardless of where their physical address is.
Representative Fishbaum?
Well, I just represent, Your Honor, there is no judicial district of Bridgeport. So I don't know why, and perhaps it's, I don't know why, but it's, I believe it's the judicial district of Fairfield. Might be located in Bridgeport, but perhaps I don't know why that would be. But my root question is, the only judicial districts that are singled out here, discriminating against the others, I guess, are Bridgeport, Hartford, New Haven, Stamford, and Waterbury. So why is the Middlesex judicial district discriminated against in this bill? By way of example, because there's others.
Senator Flexer?
Thank you, Mr. Chair. Mr. Chair, I'm sure that we would be very open to hearing from all members of this committee or all members of the legislature as to where this program should continue or be expanded. And I would also just say that there are several different programs that deal with trying to help victims of domestic violence that are only in certain judicial districts, because we are testing them out, and frankly because we are always fighting a battle of limited resources. So there are other programs that help domestic violence victims that are only available in the judicial district of Wyndham. There are other programs that are only available in certain JDs. I wish we would invest the resources in all of our judicial districts to do the Civil Gideon program, to do electronic monitoring of domestic violence offenders. I think we should do them in all of them. And if the members of this committee all agree that we should invest resources in that, then I think we'd be making great progress in ensuring that every victim of domestic violence had the resources that they needed to keep themselves safe, no matter what judicial district they happen to live in.
Representative Fishbaum?
So I didn't glean an answer to the question. I guess, and don't want to put words in anybody's mouth, is it because there's already existing programs in Bridgeport, Hartford, New Haven, Stamford, or Waterbury? Which, okay, I don't know why it says or, but is it because there's only existing programs there? Through you, Mr. Chair.
Senator Flexer?
These are the districts that have the highest numbers of restraining orders. Again, I think as we continue to work on this legislation, we'd be open to hearing feedback as to where this program is best suited, but these are the judicial districts that currently have the highest number of restraining orders and therefore have the highest number of applicants who are unrepresented and could benefit from legal representation.
Representative Fishbaum?
Thank you, Mr. Chair. So trying to figure out why it says or. It says essentially they're creating a program to provide services. So I expect these programs don't exist, although I know the services are available in many of these places. But why is it or? So it's the organization, which I guess is Connecticut Legal Services, through you, Mr. Chair.
Senator Flexer?
Yes, through you, Mr. Chair. And if you don't mind, Mr. Chair, could the good representative just remind me which line he's on again? I unfortunately lost my place.
Representative Fishbaum.
Yes, sir. Thank you. I'm in 1385 to 1393.
Thank you.
No problem. Thank you. So Connecticut Legal Services would have the choice of giving grants to Bridgeport, Hartford, New Haven, Stamford, or Waterbury in an amount not to exceed $250,000. So why are we deferring to them which one or two or three, if these are the places that is the most concentration and it's our intent to address the concentration? And I think in the bill, we provide the money, $1,250,000 is referenced in section 19. Why you would then be giving an outside agency the discretion to choose these judicial districts? Through you, Mr. Chair.
Senator Fletcher.
Thank you, Mr. Chair. Through you, again, these sections of the bill are an expansion of an existing program that we've already allocated money towards as a state. And it's a grant program that allows likely legal services to administer these programs. And again, the reason why we're focused on these particular communities, and again, I would submit that we're open to conversation about where there might be a greater need for this, but we looked at it both in terms of where there was the highest number of restraining orders and where there were, frankly, the people who were least likely to be able to potentially afford legal representation independently. And so the program would likely be run by legal services once the grant was awarded. And frankly, they're the ones right there on the ground right now who know best about people who don't have the financial resources to represent themselves in court. And so we give some discretion to them because they're the ones who are working with victims in other arenas day in and day out and would know best where to invest these resources and potentially create a program that could be expanded across the state.
Representative Fishbaum.
Thank you, Mr. Chairman. So is it the intent that each of those, assuming that Bridgeport really means Fairfield, each of those judicial districts gets $250,000? Is that the intent of this language?
Senator Fletcher.
No, the amount is to not exceed $250,000. So it could potentially be less.
Representative Fishbaum.
Okay, in fact, they could decide to give no money to one of those judicial districts, correct?
Senator Fletcher.
I don't believe that's accurate. Again, this is an expansion of a program that's already in existence, and a particular judicial district might not get $250,000 because that could exceed the cap that's contemplated just a few lines later in the bill of the $400,000.
Representative Fishbaum.
Thank you, Mr. Chairman. And then is the intent of that money, because it's free to file for a restraining order, so it wouldn't be for court fees. It's free to serve a restraining order, or it's paid for by the state. The intent of the money is to pay private lawyers to get involved in this situation, or to fund Connecticut Legal Services, because I know they presently get involved in these cases too. I'm just trying to figure out where the grant is going and what it's being used for.
Senator Fletcher.
Through you, Mr. Chair, the way it works right now is that the grant program, I believe, is administered by the Bar Association. The grant has in the past been given to legal services, and I would see no reason at this point to anticipate that that would be any different once this expansion occurs. And then legal services would have attorneys who could stand with victims in various court proceedings in the civil court, which is something they do not have right now. And what we've seen so far is a difference in outcomes. And we know that, and I'm sure many members of this committee know that when people are in court and they're represented by an attorney, they have a much different outcome, whether it's the continuation or restraining order or other issues that are debated in a court setting. There's a different outcome when you have an attorney standing next to you than when you're there by yourself.
Representative Fishbach.
Yeah, once again, I don't know that there was an answer, and I would hope that we would know what this money was actually going for, because Connecticut Legal Services, I believe, gets a block grant of sorts. Is this money to be earmarked for certain services having to do with restraining orders that are not being met presently? I'm just trying to figure out what hole we are filling here that is not being met with $1.25 million. Through you, Mr. Chair.
Senator Flexen.
Legal services, through you, Mr. Chair, would be able to pay for representation for victims in family court proceedings. That's what would happen.
Representative Fishbach.
Okay, and I don't want to belabor this at all. It's not my intent. I'm just trying to figure out what's going on here. So if Connecticut Legal Services is selecting, they're going to give $250,000 to New Haven's Judicial District. Who is being paid that money?
Senator Flexen.
Through you, Mr. Chair, I think there's a misunderstanding here. Again, there's going to be a grant program that is administered by the Bar Association. The program that currently exists has gone to legal services. There's a full RFP process. And if it were to move forward as it has in the past, and legal services were the entity that was selected through the RFP process again, they would then be able to use the resources in this grant to pay for legal representation, not at the application of a restraining order, but when you are standing in court trying to defend the ex parte order or trying to have a restraining order continued or other civil court proceedings. They would be paying for the attorney to be present with the individual there.
Representative Fishbach.
Thank you, Mr. Chair. And is that attorney an employee of Connecticut Legal Services, or are they like private, trying to figure out, once again, where the money goes?
Senator Flexen.
In all likelihood, they would be an employee of legal services. That's what the current practice is under the current program. Again, this will go through an RFP process, so the proposal that's selected could be different, but I can't imagine that it would be.
Representative Fishbach.
Okay, thank you, Mr. Chairman. And I did hear the good senator reference that Connecticut Legal Services defends ex parte orders. Is that what I heard correctly?
Senator Flexen.
No, that's not what I said.
Okay. Yeah, that was my understanding as well, but perhaps I misheard. That's all I had. Thank you, Mr. Chairman.
Thank you, Representative Fishbach. Representative Howard.
Thank you, Mr. Chairman. I was going to pose a similar question to the proponents regarding Section 18. I believe there are 9 judicial districts that are excluded in the language, and I certainly don't think that we should indicate in any way or leave any impression that any domestic violence victims in this state are seemingly less important than any others, and I'm sure that's not the intent of this bill at all. But I did just want to speak on my objection to sections 18 and 19 because I intend to vote yes on this bill today. I have sat with too many domestic violence victims and seen too many domestic violence situations at every step along the way to not vote in favor of this bill on the good intentions of its merit. So I will vote yes today, but I did want to just say on the record that I do take issue with section 18 and 19. I look forward to perhaps working on those a little bit more as they move through other committees that I may serve on. Thank you, Mr. Chair.
Thank you. Representative Pavlak D'Amato.
you, Mr. Chairman. Just a couple of questions for some clarification. I do want to thank everybody for their work on this bill, and as a family law attorney, I do look forward to seeing how some of these new sections, how the judges respond to them and how it works out in court. And, you know, there are many sections that I hope will fill some of the gaps and holes in family court that I think a lot of individuals have to deal with. With that being said, before I ask just a couple of my questions, I did want to ask Mr. Chairman, the section that has to do with the insurance portion. We did have a bill in the insurance committee that passed out of committee. It was very similar, if not the same. And so would this bill have to go through the insurance committee because of that provision?
Representative, that's a judgment that will probably be made when the bill hits the screening committees, depending on whatever rules the screening committees are currently using about what is mandatory and what is not mandatory as a referral to you, Representative Pavlak-D'Amato.
Thank you, sir. And now, as far as the substantive portions of the bill, let's see, I want to again thank everybody who worked on section 2. I really appreciate section 2 of this bill overall. Line 82, however, talks about the deprivation of basic necessities. And I was wondering if the proponents of this bill, if they believe that this section is not already covered by the automatic orders.
Senator, someone look at me so I know who I'm throwing it to. I'm not sure. Senator Fletcher? No? I'm not sure.
I apologize. The representative asked about section 2. I certainly defer to Senator Kasser on section 2 if she would prefer.
Senator Kasser.
That line is also in section 1.
I'm sorry, Mr. Chair, could the question be repeated?
Sure. Certainly, Representative Pavlak-D'Amato, would you care to restate your question?
Yes, sir. Thank you. I was looking at around line 82 when it talked about coercive control and the deprivation. It says depriving the applicant of basic necessities. And I was wondering if you believe that this wasn't already part of the automatic orders as they exist. Is it not covered under that automatic orders?
Senator Kasser.
No, that's an excellent question. My understanding of automatic orders is that yes, once an automatic order is in place, basic necessities cannot be deprived. Basic necessities, including financial resources, health insurance, housing, etc. But this applies long before automatic orders are set in motion. So it's taking that same principle and applying it far earlier in the situation.
Representative Pavlak-D'Amato.
Thank you. I appreciate that. So then just lines 83 to 85. I'll read it. It's section C, controlling, regulating, or monitoring the applicant's movements, communications, daily behavior, finances, economic resources, or access to services. Now, I think I know the intent of this section. I do have concerns that everything is kind of grouped together just for the sole purpose of, for example, what I think what I would be concerned about is if a spouse goes in and says, let's say they have a joint bank account, and one spouse says, they're monitoring my, money that I've taken out of the joint account. Let's say the spouse makes a complaint about that. And I'm not sure how the other one would figure that out or find that out, but they go in saying you're looking at the joint account. And if, a judge would make a decision based on that. So if you could maybe explain a little bit, expand on that section, whether the situation that I just provided, whether that would fall under this section.
Senator Cass.
Thank you, through you, Mr. Chair. Again, this section, which is intended to describe forms of financial abuse, does not account for ordinary actions that one might take if one shared an account with somebody else in a joint account, which is, I think, what you just described. This is meant to capture unreasonable patterns of behavior that include financial exploitation and control. So for instance, if somebody had a joint account, but they didn't have access to it, or they were told that that they didn't have access to it, or they couldn't write checks, or they couldn't see what was in it, or they just were denied their right to have equal access, knowledge, control, and decision-making power over whatever the joint asset might be.
Representative Pablo D'Amato.
Thank you for that. If you could move to section 9, this is probably, I think, something that's been long overdue. And my comment that I made about in the beginning applies to this as well. I am interested to see how this plays out in court, how judges interpret it, carry it out. If maybe you want to just expand on a couple of examples, the language used is, and this has to do with frivolous filings, and the language is intentionally fabricated pleadings. I can tell you, I have many clients who feel that this is completely out of control in court. And while, of course, a court has to respect somebody's ability to have access to the court, clearly things are done just to harass and annoy and cost their spouse or soon to be ex-spouse time, money, and just harassment. So if maybe you want to give a couple examples that would fall under this, under section 9, that would be appreciated.
Senator Cass.
Thank you, through you, Mr. Chair. Yes, and what you're describing is what we heard from so many survivors who spoke at the hearing and submitted testimony, and that they have endured years of and possibly endless amounts of time being dragged into court for frivolous, unnecessary, repetitive, duplicative, frivolous, false claims. And while everybody does have the right to due process, I also believe that everybody has the right not to be tormented and terrorized by a person who uses the court system to terrorize another person. So this is an attempt to, and albeit I know the language is still somewhat vague because it's very, very hard to create a hard standard. So some examples, you asked for examples. We heard from survivors who said that they, at one point, one woman, her abuser had filed 4 separate cases against her, criminal court, civil court, in different jurisdictions, in different states, with the only intention being that she couldn't possibly defend herself. She would just cave and give in and deplete all of her resources and have to lose her job and be unable to function just trying to defend herself from these false and truly vindictive claims. And that's the kind of thing that we know people are experiencing all over. So I can't give you more specific examples than that, but it still would be in the judge's discretion to determine when somebody is really abusing the public resource of the courts and doesn't have a legitimate claim, because maybe in many cases the claims have already been decided. The courts have already issued judgments, and the plaintiff hasn't, or the defendant hasn't followed the judgment. So they just file the same motion again and again, repetitive, duplicative, and it's already been decided. That would be a clear example.
Representative Pavlik.
I have to say that I completely agree, and I understand that the language, when I was trying to think of other words other than intentionally fabricated, I had a hard time as well coming up with something that would be enough but not too much. So I do appreciate that struggle, and I am anxious to see how this plays out. Yeah, there's many times where somebody files something and it is just for the purpose of harassment and annoying, and I don't know if I see in my experience judges recognizing the fact that one spouse has a job, has to work, has to be there, and the other one might be self-employed or have more time, and there's no respect for the person that has to be at their job. I don't know why that's not a consideration, but when somebody is trying to support their kids and pay legal fees, and it's very frustrating for that not to be taken into consideration. And overall, I'd say, and I don't think it's in the language as it exists, but when a final agreement says that parties should go to mediation first, they need to go to mediation first, or arbitration. That's what they agreed on. And I feel that courts are completely ignoring agreements that are entered orders, and they just completely disregard that. And I see it time and time again. So I appreciate the work on this bill. Yeah, I too had questions about the court districts and New Britain not being in there, but I did listen to the explanation for that. So with a couple of the provisions that I maybe don't fully agree or like, I do feel that overall this it's a good bill, and it does address a lot of the issues, or at least try to address a lot of the issues that we have to deal with in family court. So thank you.
Thank you, Representative. Representative Jillian Gilchrist.
Thank you, Senator. I just want to say that I support this policy. Thank Senator Kasser, Senator Flexer, and the leadership of the committee. Domestic violence impacts far too many people in our state, in particular during the pandemic. And I applaud this bill for a number of things, but in particular for learning from, for using what we learned during the pandemic and in the streamlining of the restraining order process. I think we should definitely take things that worked during this pandemic and continue them on in no better way than to support victims of domestic violence. And then I really applaud this new definition, which includes coercive control. It's long overdue. And so I will be supporting the bill, and I urge my colleagues to do the same. Thank you, Senator.
Thank you. Representative Palm.
Thank you, Mr. Chair. All of us who serve in the General Assembly are, of course, elected by our districts. And theoretically, at least every vote we take affects or has the potential to affect every person in the state. But I can't think of too many bills that are so clearly a benefit to everyone, to all of our districts. Domestic violence exists everywhere. It respects no geographic or demographic boundaries. And so I think this is a terribly important bill. And I am grateful to my Senate colleagues, to the chairs, to all of the domestic violence advocates who may or may not be listening, and especially to the victims for coming forward with your stories, which I know informed the very deep thinking that went into the crafting of this bill, which I believe is well researched and well thought out and sorely needed. So I was going to say I'm happy to be able to vote yes. That's not the right word. I am relieved that coercive control is finally being recognized for the damaging and pernicious effect that it has on people. And I'm very grateful to all of those who worked so hard to craft language to protect so many thousands of people. Thank you.
Thank you. Representative Veach.
Can you hear me?
I
To you,
do.
okay, to you, Mr. Chair. I just wanted to thank the good senators for all their hard work in putting this bill together. It certainly has tremendous value. I do want to add that it is a bit disappointing in that the number of districts that are being covered under such a bill with the same domestic violence issues across the state are not included in this. My district's being, part of that exclusion, if you will. And that's, I will be supporting this, but I am a bit disappointed that it is not inclusive. Thank you.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I just want to address section 9, which starts lines 614 through 620. And that has to do with the a finding of frivolous and intentionally fabricated pleadings. And I've certainly been involved in those cases. And my question is, under this language, would it not call for additional court proceedings for a judge, after the case is perhaps disposed of, for a judge to make a finding of intent and then to issue sanctions? Is that what I'm gleaning from this?
Senator Kasser?
Thank you, Mr. Chair, through you. Representative Fishbein, are you referring to section 9, vexatious litigation, that section?
Yeah, this is not, we do have vexatious litigation that's dealt with in other statutes. This is, it is section 9. This is different than what we already have, which is the concept of vexatious litigation. But yeah, section 9 is what I am dealing with, yes.
And your question was, sorry, through you.
Isn't it true that, we complain about court proceedings and the amount of court proceedings? Wouldn't it require additional court proceedings in order to invoke, employ, utilize section 9?
I don't believe so. It would still be in the court's discretion. The court could sanction a party. For instance, the court could decide that a party that has violated orders, that is in contempt of existing orders, would have to pay the attorney's fees of the other party. That would be one option. So I don't believe it would require an additional hearing or use of judicial time. In fact, the intent is quite the opposite. The intent is to give the judge the opportunity to say, enough is enough, and you have delayed this process, you have exhibited whatever it is, an uncooperative or dishonest intent here in this proceeding, and we are not going to waste additional court time and resources that are on pleadings that are not merited.
Okay, you would agree it doesn't say attorney's fees in here. It says sanction. So
correct.
That could be, you're not allowed to put a particular piece of evidence before the court. That's a sanction sometimes employed by the court. You're giving, well, I would agree if it said, attorney's fees. It doesn't say financial sanction. It's broad, but my question is, somebody has to file a motion to bring this to the attention of the court, to bring the claim to the attention of the court. You know, I would hope it doesn't get to the extent that there's 100 pleadings and the judge finally says time out, right? You want to stop it at like 5. You're gonna file a motion, right? And you're gonna have to have a hearing on, judge, they filed these 5 things. There's no basis, therefore sanction them. Well, that's additional court time. That's just a simple fact of the matter. So my question is, we already have procedures in place. 25-26 of the practice book, section G, says that a court can order that you don't file any motions for modification unless you get permission from the court. And when we had the public hearing, I asked these individuals that came before us with these complaints, did you ever employ this rule? You ever ask the judge? And they said no. I would rather not have more court time. I'd rather just nip it in the bud to begin with. I agree with the underlying intent of this, but the tools are already there. So, you know, I thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Porter.
Thank you, Mr. Chair. I just wanted to state for the record that I will be voting for this bill. And I wanted to thank Senator Flexer and Senator Castor for the great work that they did in being able to come together and collaborate to get this out the door. There are a lot of things at jeopardy. We know the pandemic has increased domestic violence, something that I don't think we're talking enough about. And I think it is critical to get this done at this point in this juncture in time. So I thank the senators, I thank you and my representative of the House that chairs this committee. And I urge every member of this committee to vote for this bill. And I'm especially excited to know that we have been able to get the coercive control in there. Being a survivor, I must say that was critical to me. So a special thank you to Senator Castor. Thank you, Mr. Chair.
Thank you, Representative Porter. Representative Fiorello.
Thank you, Mr. Chair. Through you, sir, my question to the proponents are regarding section 21, 22, and 23, where hate crime language is adjusted. My pardons, 1 second, please. Sorry, so we are removing because of and adding in motivated in whole or in substantial part by. And I wanted to understand what the intention was. And does this make those who are the aggressors of domestic violence also in the hate crime category? And what does that mean? Thank you.
Thank you, Representative. Senator Flexer.
Thank you, Mr. Chair. Mr. Chair, this does not add domestic violence victims to the existing hate crime statute. This is the change from because of to motivated in whole or substantially in part by is an attempt to make our hate crime statute a little bit more flexible. We've seen, particularly the conversation we've been having across the country in recent weeks and months, that sometimes our hate crime statutes can be very rigid and prevent a prosecution of a situation where you may know that it is in fact a hate crime, but the language in the statute is not broad enough. And so this is an attempt to make sure that Connecticut has some of the strongest hate crime statutes in the country.
Thank you, Senator. Representative Fiorello.
Thank you, sir. Through you again. So if I understand the clarification, then it is to change the hate crime writing now so that the victims of domestic violence can also be recognized as victims of hate crime. And then what is the judicial consequence of that? Does that increase jail time, or how does that actually manifest? And what does it really mean for those who are prosecuted for the hate crimes, again, in a domestic violence situation? Thank you, Mr. Chair.
Senator Flexer.
Thank you, Mr. Chair. I said in my last answer, this does not add domestic violence victims to the hate crime statute.
Representative Fiorello.
Okay, so then why is it part of this legislation then? So it actually doesn't have anything to do with the overall topic of domestic violence? Just to clarify, Mr. Chair.
Senator Flex.
Thank you, Mr. Chair. Mr. Chair, the bill that is before us this afternoon, which we are debating right now, is a compilation of two different bills. And the original bill of Senate Bill 6, which is a bill that was heard before this committee, the title of which was an act concerning domestic violence and criminal justice reforms. Many of the provisions of that bill are in the bill that we are debating right now, Senate Bill 1091. And the sections of this bill that the representative is asking questions about were heard in the public hearing and would fall under the criminal justice reforms that were in the originally filed bill. And the language here before us today is no different than what was in those sections in Senate Bill 6.
Representative Fiorello.
Okay, thank you for that explanation. I'm good, Mr. Chair. Thank you.
Thank you, Representative Fiorello. Representative Bimbis.
Thank you, Mr. Chairman. And actually, just a quick follow-up to that last line of questioning. What was the reasoning to join these two bills?
I guess, Representative, I just want to make sure, do you mean Senate Bill 6 and 1060?
Yes.
Yes. So, Representative, while Senate Bill 6 was one of, as you may know, the Senate has several bills, usually 1 through 6 or 1 through 7, that are big omnibus bills that you will find in the committee. While Senate Bill 6, which was in the Judiciary Committee, dealt with several issues. One of the bigger issues, or the biggest issue in the bill, was the issue of domestic violence. But there was a second domestic violence bill, Senate Bill 1060, and there was some space between the bills, and we joined the bills because we're not going to pass. So we're not going to have two separate debates on the same subject, and we've merged them together because they are the same subject, and it's cleaner to do it that way. To you, Representative Bimbis.
Thank you, Mr. Chairman, for that explanation. I've been intently listening to the discussions and the dialogue, and I've also very much have enjoyed working on domestic violence proposals in the past and supporting them out of our committee. And I think that there's been great work done by the advocates over the years, and certainly a lot of changes that over the years and input has been made on those that I believe that the proposals have been better. I think that there's been a lot of really good issues discussed, some items raised in that regard. And then Mr. Chairman, I did hear also in your opening remarks regarding the bill that additional work is potentially going to be done on the bill itself. So in order to make sure that those discussions continue and good work gets done, I certainly at this moment in time will be voting against the proposal in committee in the hopes that we certainly can continue to have a very good positive discussions on this proposal so that ultimately when it does reach the chambers, it's something that we can all support in a bipartisan manner. So thank you again, Mr. Chairman, and thank you again for everyone who's been answering the questions and asking questions on this proposal.
Thank you, Representative. Comment or question from other members of the committee, comment or question. I do not see any. I would then ask Madam Administrator if you would call the roll, please.
That was 1091 JFF goes up to LCO number 6573. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield is voted in the affirmative. Representative Staffstrom.
Representative Staffstrom in the affirmative.
Representative Stastrom has voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel, Representative Fishbein.
Representative Fishbein votes no.
Representative Fishbein has voted no. Senator Anwar.
Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan is voting yes. Senator Champagne.
Senator Champagne votes yes.
Could you please repeat, Senator Champagne?
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley is voting yes. Representative Curry.
Representative Curry votes yes.
Representative Curry is voting yes. Representative Dillon.
Representative Dillon votes yes.
Could you please repeat?
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative Doucette.
Representative Doucette votes yes.
Can you just repeat, please?
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Could you please repeat?
Representative Dubitsky votes no.
Representative Dubitsky has voted no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello is voting no. Senator Flexer.
Senator Flexer votes yes.
Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Could you please repeat?
Representative Fox votes yes.
I'm sorry, we were seeing Representative Labriola.
Representative Fox votes yes.
Third time's a charm. Excellent. Thank you so much, Representative Fox. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey. Representative Harding.
Representative Harding votes yes.
Representative Harding is voting yes. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes yes.
Representative Howard is voting yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Representative Pavlak D'Amato has voted yes. Representative Porter.
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbus.
Representative Rabimbus votes no at this time.
Could you please repeat?
Representative Rabimbus votes no at this time.
Thank you so much.
Thank you.
Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative. Representative Young.
Representative Young votes yes.
Thank you, Representative Young. And I see Representative DeMassa has his hand raised.
Representative DeMassa votes yes. Thank you, Madam Clerk.
Representative DeMassa has voted yes. Thank you. Oh, Representative Godfrey's in too.
Thank you. Representative Godfrey votes yes.
Representative Godfrey has voted yes. Thank you.
Thank you, Madam Administrator. Next, we'll turn to number 4 under Roman numeral 3, which is Senate Bill number 1059, an act concerning the Correction Accountability Commission, the Office of Correction Ombuds, the use of isolated confinement, seclusion, and restraints, social contacts for incarcerated persons, and training and workers' compensation benefits for corrections officers. There is a JFS on this, so it's LCO 6549. Ask for a motion for the JFS language.
So moved, Mr. Chair.
Second.
Thank you, Representative Porter. Second, Representative Palm. Just for the administrator, to be clear, was motion by Representative Porter and second by Representative Palm. This is a bill with the JFS language that looks to deal with the issue of an ombudsperson and the services offered by an ombudsperson. It also deals with how we appoint the ombudsperson through the governor, and the nomination would come to the Judiciary Committee, as we do with many of the positions that we have here in the state. It deals with transparency around the issue of restrictive housing and restraints in our correctional facilities. It deals with restricting the usage of what we tend to refer to as solitary confinement. But here, what we are doing is generally making sure that there are 8 hours out of the cell, and there are exceptions to that. They take into account that there are serious incidents such as a lockdown, substantial threats of harm to individuals in our system, the request for segregation for protection, and it allows for the increase in that time in 8-hour segments. It also requires us to diffuse and de-escalate before we use restraints. It also asks us to develop the policies for social contacts for incarcerated persons. And it deals with the training and workers' compensation issue of our hardworking corrections officers. And I see that there is a comment or question from Representative Fishbone.
Yes, thank you, Mr. Chairman. Mr. Chairman, just a few questions. In line 135, this correction ombudsman, which seems to make sense. I think that's it. I'm sorry, let me put my video on. I'm sorry. I apologize. The correction ombudsman seems to be an important thing, and just had a question about that. We're giving this individual the ability to issue subpoenas. And am I to understand that because of that, we are requiring the individual to be a commissioner of the Superior Court or an attorney?
Representative Fishbone, so as you, can you tell me what that line starts with? Because my copy printed out without numbers, so I'm struggling a little bit here. I'm trying to get to a copy with numbers.
Absolutely, sir. It's subsection I of parent 7, section 1, I believe that. Yes. On my copy, it's page 6, but I don't think you're gonna have the same page numbers.
Through you, Mr. Chair. Sorry, it's one of those days. The section there
starts the correction ombuds may issue subpoenas to compel.
I do not believe anything in this section requires that person be an attorney, as it is written through you, to you, Representative Fishbone.
Thank you, no problem. I know it's been a long day already. I know. And is a correction ombudsman, since they're not an attorney, are they required to take an oath of some sort? My understanding is that they wouldn't.
Through you, to you, Representative Fishbone, I don't believe there's anything here that requires that an oath be taken.
Okay. So moving forward from that, in M, subsection M, which is a couple of pages after that, we are not requiring that individual to have certain licensure criteria, and yet we're holding them harmless, which seems a little counterintuitive, you know, considering we had this qualified immunity discussion over the summer and, you know, still going on. Why would it be good policy to have a low bar, it appears, for the acumen of the individual, and yet we're going to hold them harmless?
Representative Fishman, I'm not sure what you mean by a low bar for the acumen of the individual, considering that I'm not an attorney either. But despite that, I think that the section that you're referring to holds them harmless unless the act is an act that is wanton, malicious, or grossly negligent, which is not dissimilar from what we actually did with the police accountability bill.
Understood, sir. And I meant no offense by the fact
I didn't take it as an offense. I just pointed that out.
No, but I will also point out that I don't believe, because we are seated state representatives and senators, that we can issue subpoenas. So that's the distinction here. So,
well, I think that actually the chairs of committees have some subpoena power, so that
okay,
we do have that power. Just to be accurate.
No problem. You know, the hold harmless provision is of concern, Mr. Chairman, and with that, I believe the clerk is in possession of an amendment. The intent of the amendment is to remove that subsection M of section 1, lines 169, 178, to remove that hold harmless provision, and I do move the amendment.
The amendment has been moved by Representative Fishman. Is there a second? Is there a second?
Second.
It's been seconded by Representative Harding. You may discuss it further should you care to, Representative Fishman.
Thank you, Mr. Chairman. So just clearly, very straightforward. This amendment strikes lines 169 through 178, which provide for a hold harmless provision against this individual. So I think it's the appropriate way to go forward, and I ask my colleagues to support the amendment. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Is there a comment or question from members of the committee? Representative Rabindus.
Thank you, Mr. Chairman. Mr. Chairman, I guess a question would be, why in the draft of the original proposal
Representative Rabindus, I completely lost you on that. I hate to do this, but could you reframe the question?
Sure, not a problem. So my question would be, in the original provision for this position.
I'm sorry, I didn't get. If anyone else got the question and can.
I think the question was, in the original proposal that was before the committee, was this hold harmless provision in that original language? To I guess Representative Rabindus, I don't have the original language in front of me currently. What I will represent is that what we were doing with the drafting, and as she knows, having been a long-standing member of the committee and the General Assembly, what we were doing was just taking the language of the original bill and incorporating it into the JFS. There were some changes with the ombudsperson because one of the sections was removed, and we had to think about how we would appoint this person. But the effort was to duplicate what we had in the original bill. To you, Representative Rabindus.
Thank you, Mr. Chairman. And my understanding that the connection may not be the best. So certainly I'll reserve any other questions, and I would stand in support of the amendment because as immunity has been a discussion in this committee and continues to be a discussion, I'm not exactly sure how I can reconcile that individuals believe that immunity should be stripped for some people and should be proposed in new legislation for new positions. So I am in support of the amendment, but I certainly look forward to the continuation of this conversation. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members? I don't see any. I would just say, and I did have a conversation with the proponent of the amendment about the amendment. I would ask for a negative vote because I don't think that what we are trying to do here is give immunity in a way that is new. I think when acts are wanton, malicious, when they're willful, when they're grossly negligent, then people should be liable for the actions they take. But when they're merely in the course of doing their job, they really should have due protection. And I don't think we are stepping outside of that type of thought here. But what I did represent to Representative Fishbein was, given the moment at which his amendment comes, there may be the case that upon further discussion, we may come to see eye to eye, and I will represent what I've represented before. I will engage him in that conversation beginning next week. So I would ask for a negative vote. If there's no further conversation, I'd ask the administrator to call a roll.
Alrighty, and that was Amendment A offered by Representative Fishbein and seconded by Representative Harding. Senator Winfield.
Senator Winfield in the negative.
Senator Winfield has voted in the negative. Representative Stafford.
Representative Stafford votes no.
Representative Stafford has voted no. Senator Kasser.
Senator Kasser votes no.
Senator Kasser has voted no. Representative Blumenthal.
Representative Blumenthal votes no.
Representative Blumenthal has voted no. Senator Kissel. Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar.
Senator Anwar votes no.
Anwar has voted no. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes no.
Representative Conley has voted no. Representative Curry.
Representative Curry votes no.
Representative Curry is voting no. Representative Dillon.
Representative Dillon votes no.
Representative Dillon has voted no. Representative DeMassa.
Representative DeMassa votes no.
Representative DeMassa has voted no. Representative Doucette.
Rep. Doucette votes no.
Rep. Doucette has voted no. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer. Representative Fox.
Representative Fox votes no.
Representative Fox has voted no. Representative Gilchrist. Representative Godfrey.
Yes,
Hi,
there's Representative Gilchrist.
No,
Representative Godfrey votes no.
Please repeat, because we were looking at both of you at the same time.
Okay, Representative Godfrey votes no.
Thank you. Representative Godfrey has voted no.
Oy.
Representative Gilchrist, go ahead.
Sorry about that. Representative Gilchrist votes no.
Representative Gilchrist has voted no. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell.
Senator Haskell votes no.
Senator Haskell has voted no. Representative Howard.
Representative Howard votes yes.
Representative Howard is voting yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser.
Senator Lesser votes no.
Senator Lesser has voted no. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes no. Representative Palm has voted no. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Dr. Amato has voted yes. Representative Porter. Representative Quinn.
Representative Quinn votes no.
Representative Rabimbus.
Representative Rabimbus votes yes.
Could you please repeat?
Representative Rabimbus votes yes.
Thank you, Representative Rabimbus.
Thank you.
Representative Riley.
Representative Riley votes no.
Representative Riley has voted no. Senator Sampson. Representative Sims. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes no.
Representative Walker has voted no. Representative Young.
Representative Young votes no.
Representative Young has voted no.
Madam Administrator, Senator Flexer would like to vote no.
Thank you. Senator Flexer has voted no. Anyone else that didn't have an opportunity?
Whenever you're ready, Madam Administrator.
Thirty-three members voting yay, 11 nay, 21, 0 abstentions, absent not voting 6.
Thank you, Madam Administrator. The amendment fails. Comment or question on the language before us? Comment or question? I do not see any. Madam Administrator, I would ask you to call the roll.
That was on Senate Bill 1059, JFS proposed bill 6549. Senator Winfield.
Senator Winfield, in the affirmative.
Senator Winfield has voted in the affirmative. Representative Staffstrom.
Representative Staffstrom in the affirmative.
Representative Staffstrom has voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes no.
Representative Fishbein has voted no. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes no.
Senator Callahan has voted no. Senator Champagne.
Senator Champagne votes no.
Senator Champagne has voted no. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative DeMassa.
Representative DeMassa votes yes.
Representative DeMassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Representative Dubitsky has voted no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello has voted no. Senator Flexer.
Senator Flexer votes yes.
Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
And Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell. Representative Howard.
I apologize, Madam Administrator. Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes no.
Representative Howard has voted no. Representative Labriola.
Representative Labriola votes no.
Representative Labriola has voted no. Senator Lesser. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pablo D'Amato.
Pablo D'Amato votes no.
Representative Pablo D'Amato has voted no. Representative Porter. Representative Quinn.
Representative Quinn votes yes.
Representative
Representative Porter votes in the affirmative.
Could you please repeat?
Representative Porter, I'm sorry, votes no.
I think if you want to vote with the rest of your colleagues, you.
Is this the amendment? I'm sorry, I got.
No, the
called away
amendment
for a
has
minute.
passed. Thank you. This is the bill itself.
The bill itself, yes, I would like to vote in the affirmative. Thank you, Deb.
Thank you. Representative Porter has voted in the affirmative. Representative Rabimbus.
Representative Rabimbus votes no.
Representative Rabimbus has voted no. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes no.
Representative Veach has voted no. Representative Walker. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative. Thank you, Representative Walker.
Senator Anwar votes yes.
Senator Anwar has voted yes. Thank you.
Thank you.
Thank you, Madam Administrator. Next will be number 7 under Roman numeral 3, which is House Joint number 68. Resolution granting the Claims Commissioner an extension of time to dispose of the claim of Harvey Agerson. Is there a motion?
So moved.
Second.
Moved by Representative Fishbein, seconded by Representative Staffstrom. Discussion.
Mr. Chair, just for the record, I believe this is substitute language LCO 6474. Did you mention that?
I did not. Thank you very much for correcting me. You are correct. It is LCO 6474.
Thank you, Mr. Chair. Mr. Chair, this is the first of several claims resolutions that we're going to take up today. I think, as folks know, we have several years worth of claims against the state that have built up in this committee due to lack of legislative action the last 2 years on claims, in part due to the pandemic. Despite the diligence of members of this committee and certainly the admirable help of our legal interns on this committee, we continue to work through those claims and decide on final disposition of them. What we are asking the committee to do here today is to pass out 10 of the resolutions so that we can have vehicles, so to speak, for when we get to the House floor of which claims to approve, which ones to deny, which ones to grant additional time to, and the like. And I would ask that, after discussion on this one, we should be able to move fairly quickly through the other ones. But the idea is just to keep these moving as we hit our deadline so that we can sort through these claims as we get towards the end of session. Thank you, Mr. Chair.
Thank you, Representative Staffstrom. I want to see if Senator Lesser is on. I think he needs to make a statement. Senator Lesser? Perhaps Senator Lesser had to recuse himself, so perhaps he already jumped off.
Excuse me, Mr. Chair.
Yes.
Sorry, what is the number of this resolution again?
This is number 7 on our agenda is House Joint 68.
Okay, Mr. Chairman, I'm going to recuse myself because of the conflict of interest.
Okay, Representative Blumenthal has recused himself. Senator Lesser, I see you there now.
Yes, thank you, Mr. Chairman. Mr. Chairman, I'd like to recuse myself as well.
Senator Lesser has recused himself. Senator Champagne?
I just have a question that basically stated that that these are vehicles. Is this going to be just for this one claim, or are you going to add other claims on as we go forward onto this one?
Ultimately, and I think you look in the S language, there's multiple claims in this. I think at the beginning of the session, we had 300 some odd claims that each were assigned their own resolution number. Traditionally, what the legislature does is try to group them together so that typically we try to group we try to group them together so that we don't have to vote on 300 resolutions separately in the House. So that would be the intent here, is to keep 10 vehicles alive in order to be able to do that grouping as we get to the House floor.
So voting for this, we're actually could be voting for up to 10, not just this one.
Could be up to it could be up to several dozen. We're keeping 10 vehicles alive to be able to group claims together eventually when we get to the House floor.
Okay. Thank you.
Thank you, Senator Champagne. Comment or question from other members of the committee? Comment or question? Seeing none, Madam Administrator, if you call the roll.
And this was item number 7 on the agenda, House Joint Resolution 68 has proposed substitute language in it for a House Joint Resolution proposed L number 6474, which groups a bunch of extensions together, granting an extension time. Senator Winfield.
Senator Winfield in the affirmative.
Representative Stafford.
Representative Stafford in the affirmative.
Representative Stafford in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal has recused himself. Senator Kissel. Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar.
Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative DeMassa.
Representative DeMassa votes yes.
Representative DeMassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer. Representative Fox.
Senator, I'm sorry, I was on mute, Madam Administrator, and I'm sorry, Representative Fox. Senator Flexer votes yes.
Senator Flexer has voted yes. Thank you. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
And Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser has recused himself. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Representative Pavlak D'Amato has voted yes. Representative Porter.
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn is voting yes. Representative Rabimbus.
Representative Rabimbus votes yes.
Representative Rabimbus has voted yes. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative, and Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. The next item is number 8, House Joint number 75, resolution confirming the decision of the Claims Commissioner to deny the claim against the state of Edwin Andino. There is a substitute. It is LCO 6529. Is there a motion?
So moved.
Second.
Moved by Representative Staffstrom, seconded by Representative Fishbon. Is there discussion? Is there discussion? I don't see any. Is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move item number 8, which is House Joint Resolution number 75, LCO 6529, to the consent calendar.
Is there objection? Seeing none, this item will be placed on consent. Next on our agenda is number 9, House Joint number 78, resolution confirming the decision of the Claims Commissioner to dismiss the claim against the State of American Rock Salt Company, LLC. There is JFS language. The LCO is LCO 6531. Is there a motion?
So moved.
Second.
Moved by Representative Staffstrom, seconded by Representative Fishbon. Is there discussion? Being no discussion, is this an item that is consentable?
Yes, sir. I make a motion that we move item number 9, House Joint Resolution 78, LCO 6531, to the consent calendar.
Is there objection? I see none. Therefore, item number 9, House Joint number 78, LCO 6531, will be placed on the consent calendar. Next is number 10 on our agenda, House Joint number 103, resolution granting the Claims Commissioner an extension of the time to dispose of the claim of Joe Burgos Vega. The LCO number on the substitute is LCO 6487. Is there a motion?
So moved.
Second.
Moved by Representative Staffstrom, seconded by Representative Fishbon. Is there discussion? I see none. Is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move item number 10, which is House Joint Resolution 103, LCO 6487, to the consent calendar.
Thank you, Representative Fishbon. Is there discussion? Objection? I see none. This item will be placed on the consent calendar. Just for clarity, that is number 10, House Joint number 103, LCO 6487. We'll next be at number 11, House Joint number 140. There is a substitute. The LCO is 6493. The title is Resolution Granting the Claims Commissioner an extension of the time to dispose of the claim of Daniel Duffy. Is there a motion?
So moved.
Second.
Moved by Representative Staffstrom, seconded by Representative Fishbon. Discussion. Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 140, LCO 6493, to the consent calendar.
Thank you, Representative Fishbon. Is there discussion? Objection? Seeing none, we will move House Joint number 140, LCO 6493, to the consent calendar. Next, we have number 12 on our agenda, which is House Joint number 175, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Bryant Jefferson. There is a substitute. The language, the LCO is LCO 6541. Is there a motion?
Mr. Chair,
Yes.
if you could recognize Senator Lesser.
I see he raised his hand. With Representative Senator Lesser.
Yes, Mr. Chairman. Mr. Chairman, I would like to recuse myself on this item.
Okay, Senator Lesser has recused himself.
I move the JFS.
And sorry, Representative Blumenthal will recuse himself as well.
Representative Blumenthal has recused himself on this item as well. It has been moved by Representative Staffstrom, seconded by Representative Fishbon. Is there discussion? Seeing none, Madam Administrator, would you call the roll?
And that was item number 12, HJ 175. Proposed substitute HJR LCO 6541. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield is voted in the affirmative. Representative Staffstrom.
Representative Staffstrom in the affirmative.
Senator Staffstrom is voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Casser has voted yes. Representative Blumenthal has recused himself. Senator Kissel, Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar.
Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley, Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Could you please repeat?
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative Damaso.
Representative votes yes.
We didn't hear your name.
Representative Damasa votes yes.
Thank you. Representative Damaso has voted yes. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky is yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat?
Senator Flexer votes yes.
Perfect. Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes yes.
Could you please repeat?
Absolutely. Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell.
Senator Haskell votes yes.
You'll have to repeat because we're still seeing.
I apologize. Senator Haskell votes yes.
Perfect. Senator Haskell has voted yes. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser has recused himself. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak-D'Amato.
Pavlak-D'Amato votes yes.
Could you please repeat?
Pavlak-D'Amato votes yes.
Perfect. Representative Pavlak-D'Amato has voted yes. Representative Porter.
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbus.
Representative Rabimbus votes yes.
Just please repeat.
Representative Rabimbus votes yes.
Perfect. Representative Rabimbus has voted yes. Representative Riley. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Can you please repeat?
Representative Sims votes in the affirmative.
Perfect. Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. Next on our agenda is number 13, House Joint number 185, resolution confirming the decision of the Claims Commissioner to dismiss the case against the state of Joshua Kahan. There is substitute language. It is LCO 6522. Is there a motion?
So moved.
Second.
There is a motion by Representative Staffstrom, a second by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 185 LCO 6522 to the consent calendar.
Thank you, Representative Fishbein. Is there discussion? Seeing none, House Joint number 185, LCO 6522 will be placed on the consent calendar. Next on our agenda is item number 14, House Joint number 202, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Casey Lewis. There is substitute language. It is LCO 6530. Is there a motion?
So moved.
Second.
Moved by Representative Stasham, seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 202, LCO 6530 to the consent calendar.
Is there discussion? Seeing none, House Joint number 202, LCO 6530 will be placed on the consent calendar. Next, we are at number 15, House Joint number 211. Resolution granting the Claims Commissioner an extension of the time to dispose of the claim of Barbara McCara. There's substitute language. It is LCO 6547. Is there a motion?
So moved.
Second.
The item is moved by Representative Stasham and seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 211, LCO 6547 to the consent calendar.
Is there discussion? Seeing none, House Joint number 211, LCO 6547 will be placed on the consent calendar. We are at item 16, which is House Joint number 214. Resolution confirming the decision of the Claims Commissioner to deny the claim against the state of Marek Mariansky, PhD. There's substitute language. It is LCO 6524. Is there a motion?
So moved.
Second.
Moved by Representative Stasham, seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 214, LCO 6524 to the consent calendar.
Thank you, Representative Fishbein. Is there discussion? Seeing none, House Joint number 214, LCO 6524 will be placed on consent. We are at item number 17, House Joint number 239, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Lorenzo Osborne. There is substitute language. It is LCO 6538. Is there a motion?
So moved.
Second.
Moved by Representative Stafstrom, seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 239, LCO 6538 to the consent calendar.
Is there discussion? Seeing none, House Joint number 239, LCO 6538 will be placed on the consent calendar. We are at item number 18, House Joint number 264, resolution confirming the decision of the Claims Commissioner to dismiss the case against the state of Eddie Rodriguez. There is substitute language. It is LCO 6534. Is there a motion?
So moved.
Second.
Moved by Representative Stastrom, seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 264, LCO 6534 to the consent calendar.
Thank you, Representative Fishbein. Is there discussion? Seeing none, House Joint number 264, LCO 6534 will be placed on the consent calendar. We are at number 19, House Joint number 270, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Christopher Santiago. There is substitute language. It is LCO 6542. Is there a motion?
So moved.
Second.
Moved by Representative Stastrom, seconded by Representative Fishbein. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 270, LCO 6542 to the consent calendar.
Thank you, Representative Fishbein. Is there discussion? Seeing none, we will move House Joint number 270 with the LCO 6542 to the consent calendar. We are at item number 20, House Joint number 301, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Amy Suda. There's a substitute language which has the LCO of 6526. Is there a motion?
So moved.
Second.
Moved by Representative Staffstrom, seconded by Representative Fishbane. Is there discussion? Seeing none, is this an item that is consentable?
Yes, Mr. Chairman, I make a motion that we move House Joint Resolution 301 LCO 6526 to the consent calendar.
Thank you, Representative Staffstrom. Is there discussion? Seeing none, we will move House Joint number 301 with the LCO 6526 to the consent calendar. And that will put us at item number 21 on our agenda, which is House Bill number 6505, an act concerning court operations. I know there's a JFS, although on my...
Mr.
Yes.
Chairman.
Yes, sir.
We're going to hold that.
Oh, that's right. I forgot about that. Thank you for reminding me. The day has gotten away from me. Okay, number 22 on our agenda, House Bill number 6506, an act concerning procedures of the Office of the Claims Commissioner. There's JFS 6558. Is there a motion?
So moved.
Second.
Second. Moved by Representative Staffstrom, seconded by Representative Fishbane. Representative Staffstrom.
Thank you, Mr. Chair. Mr. Chair, as we just said with the resolutions, there certainly is a backlog of resolving claims against decisions that have been made by the Claims Commissioner. There also is a backlog of claims at the Claims Commission office itself. We heard testimony during the public hearing of claims that date back 5, 7, even longer years. You know, this is a difficult issue because in some respects, you know, obviously we have to, in many respects, we have to recognize and appreciate the doctrine of sovereign immunity, which recognizes that not every time someone decides to sue the state or a state actor, that claim should go to Superior Court. But by the same token, certainly a claim that has been waiting in the Claims Commission for 5, 7 years, and someone is waiting really to find out even whether the doors of the courthouse will open to them for them to proceed with their claim is far too long, and is a due process and access to justice issue. The bill before us attempts to put in place some different procedures before the Claims Commission. It works to find a process by which certain claims could go to court without a full kind of hearing before the Claims Commissioner, so to speak, be taken up on the papers. Also looks to put in place some dates. And frankly, the other piece to this that is not currently reflected in this bill, but I think needs to be said as this moves forward, is we need to look at the resources that are available to the Claims Commissioner, and whether the volume of work she has in her office vis-a-vis the staff that is available to her is appropriate. Mr. Chair, the bill before us very much remains an open conversation. I highly doubt this is the final version of the bill that would run in the House. I know there have been productive conversations between members of the plaintiff's bar and the Office of the Attorney General, who generally defends these cases on behalf of the state, particularly over the last week. I would ask that this committee keep this bill as a vehicle moving today, so that those conversations can continue, and that we can deal with and as the legislature assist in dealing with that backlog before the Claims Commission office. Thank you, Mr. Chair.
Thank you, Chairman Staffstrom. Ranking Member Fishbane.
Thank you, Mr. Chairman. Mr. Chairman, I agree with most of what the good chairman had to say. You know, when I first started this session, someone came to me and said, you know, we want to do something with the Claims Commission and, you know, have these dates and all this stuff. And my initial reaction was, no. I mean, I'm not going to support that. You know, we have a process. We should use the process. And, you know, is the process that bad? And they said, yes. And I said, prove it to me. And yeah, we got some issues. So, you know, I am happy that we were able to work together on this for the most part. You know, I understand a work in progress, but I think this does some good stuff because, you know, these people need some closure. They need to know, you know, whether or not they can proceed. And in some of these cases, evidence is gone, witnesses are gone, you know, and the passage of time just impacts inappropriately that due process. And our Connecticut Constitution clearly says that everybody should have the right to redress in our courts. And this is negatively impacting that. So in our discussions, Mr. Chairman, we did discuss that after the gatekeeper function went into place, going forward with claims that are not as ripe as some of the ones here, that there would be a procedure by which one could get permission to sue based upon passage of time and them representing that they have a viable case. And in those negotiations, we talked about that provision of time would not be 18 months, it would be 24 months. And I noticed that the language before us today, although the prior language had 24 months, this language goes back to the 18 months. And I know we've had the discussion earlier today. Mr. Chairman, I'm going to make a motion that at lines 155 and 160, that 18 is replaced with 24. So moved.
I will second the motion, Mr. Chairman.
Thank you. Moved by Representative Fishbein, seconded by Representative Staffstrom. Is there a comment, question on the amendment before us, the oral amendment before us?
Mr. Chair, I consider this a friendly amendment and would ask my colleagues to support it.
Very much, Chairman Staffstrom. Seeing no comment, I believe we can vote in voice vote. So all in favor, say aye.
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 All opposed? All opposed? Nay? Abstentions? The ayes have it. The amendment will be adopted. Further comment on the bill before us. Representative Gilchrist.
Thank you, Mr. Chair. As someone who is new to the Judiciary Committee, I didn't know much about this process, but sitting through the public hearing, it was evident that there is a problem with the process. And so I'm happy to see this bill moving forward. Thank you, Mr. Chair.
Thank you, Representative Gilchrist. Is there a comment or question from other members of the committee? Comment or question? Is this an item that is consentable?
Mr. Chairman, I wish it was. My understanding is that it perhaps is not, and I don't want to take that risk.
Absolutely. We will have a roll call to be absolutely sure. Madam Administrator, when you are ready, please call the roll.
Over the light. That was item number 226506. Now concerning the procedures of the Office of the Claims Commissioner, JFS proposed substitute LCO number 6558 with Amendment A offered by Representative Fishbein, seconded by Representative Staffstrom. Senator Winfield.
Senator Winfield in the affirmative.
Representative Staffstrom.
Representative Staffstrom in the affirmative.
Representative Staffstrom in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Senator Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
I see now that 888 is passed, we're going to do these kinds of things, right? Representative Fishbein votes in the affirmative.
Representative Fishbein has voted in the affirmative. Senator Anwar.
Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Representative Dillon votes yes. Representative Damassa. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer.
Senator Flexer votes yes.
Could you please repeat your name?
Senator Flexer.
Thank you. Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes yes.
Representative Harding has voted yes. Senator Haskell. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser.
Senator Lesser votes yes.
Senator Lesser has voted yes. Yes. Representative Luxembourg. Representative O'Day. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes yes.
Representative Pavlak D'Amato has voted yes. Representative Porter.
Representative Porter votes in the affirmative.
Representative Porter has voted in the affirmative. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis.
Representative Rabimbis votes yes.
Representative Rabimbis has voted yes. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims. Representative Veach.
Representative Sims votes in the affirmative.
Could you please repeat Representative Sims? Representative Sims, could you please repeat?
Sims votes.
Still not catching audio.
Representative Sims votes in the affirmative.
Perfect. Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker's voted in the affirmative. Representative Young.
Representative Young votes yes.
Could you please repeat?
Representative Young votes yes.
Representative Young has voted yes. Thank you.
Thank you, Madam Administrator. We will next go to item number 24, which is House Bill number 6667, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. There is substitute language. It is LCO 6557. Is there a motion?
So moved.
Second.
Moved by Representative Walker, seconded by Representative Staffstrom. Representative Walker.
Thank you, Mr. Chair. Thank you, everyone. The bill before you today is a continuing product of the Juvenile Justice Planning and Operation Committee. It is one of multiple bills that we've been doing addressing our juvenile justice system. I will go through the sections quickly so that I can provide you with the information. I want to say that we did have some other sections in this bill, but under negotiations and discussion, we have admitted that we will accept these, but we would prefer to add some maybe in the next year to make some of the changes. Section 1 was to raise the age of jurisdiction from 7 to age 10. Section 2 is an implementation team, and that implementation team will be used to help Department of Children and Families develop an operation plan to create an education unit pursuant to Section 4 of this Act. The implementation team will start the oversight of the education format for our juvenile justice population that are under the custody of the state. Section 3 is effective date of October 1st, 2021, is an act to establish education units
within the Department of Children and Families and the education of any child who resides in any juvenile justice facility or any child that is incarcerated. Part of the problem that we were finding was that children in the juvenile justice system would never seem to obtain the necessary credits or support in order for them to continue their education while under the custody of the state. So the sections that are addressing Department of Children and Families, they have been willing to actually take on the operation of the education system under the USD2. And with that, they will also provide access for credit retrieval. They will also provide counseling, education counseling. Section 4, the Department of Education shall provide a list of people who will perform the function of reentry coordinator. If you remember, we passed last year that all school districts were supposed to have a reentry coordinator for children moving in out of the juvenile justice system back into the school system. Unfortunately, that was never done, so we have asked them to facilitate that this time and provide that list to all of the facilities, the detention centers, group homes, etc., so that everyone can know who to contact. Section 5 is the Regional Board of Education under their jurisdiction will address any of the necessary things for kids on 17 and under who are whose jurisdiction, local and regional boards of education whose jurisdiction for students would otherwise be attending schools if such student were not educated under the oversight of DCF shall be attaining an award of a diploma through the USD2 if their local LEAs do not provide them with that. Section 6, the Commissioners of Education and Children and Families shall develop a system of standard conversion of credits. Part of the problem that we also found that if a child was in detention and then moved to, let's say, Manson, and then went back to their school district, the math program that they may have been provided in detention versus the math program in Manson Youth is not necessarily compliant with the regular K-12 system of the LEA that they're from. So this would establish that compliance through the USD2. Section 7, students placed in the JJ facility and any other incarcerated facility after this date shall be able to obtain educational records and transfers. Section 11 establishes a committee for the purpose of developing a plan to phase in a ban on suspensions and expulsions. We studied this quite a bit in our Juvenile Justice Policy and Operation Committee, but it is the will of the body of the Judiciary Committee to have this one explained in more detail. So in order for us to facilitate making those changes, we will accept that, and not later than January 1st, 2022. The committee shall complete a report so that we can provide it to the Judiciary Committee in hopes to obtain the support from them. Section 9 is the erasure of all records when a child has been convicted of a delinquency or adjudicated as a member of a family with service needs, the responsibility of admitting to having committed to a delinquent act and have subsequently discharged from the supervision of the Superior Court from the custody of the Department of Children and Families or the care of another institution shall have his records erased automatically. Section 10. We will establish a committee to study the usage of telephones to provide the juveniles with call rates and needs that for communication with their families. Section 11 is the chemical agents are still being used in the Department of Correction on juveniles under the age of 18. Effective under this section, July 1st, 2022, the Commissioner of Corrections and the Children on Family and the Court Supported Services Division shall make sure that no chemical agents will be used on any child under the age of 18. Section 12, Section 12 is the implementation team to develop plans for mandatory pre-arrest diversion for low-risk kids. And that is there another section? I think that's it.
This is section 13, and that's the implementation plan about secure housing.
Right, for the implementation to move children from Manson Youth to the Court Supported Services Division oversight as of January 1st, 2023.
Thank you, Representative Walker. Representative Fishbein.
Sorry. Thank you, Mr. Chairman. Just a clarification. With regard to line 291, the erasure issue.
Okay.
Yep.
Okay. With the erasures, I'll try. I don't have a copy with the lines on it, so it's section 9.
Section 9.
Okay. All right.
And well, it's the only change in there. The erasure. So is it any crime committed by a juvenile? Let's say it's a serious crime. You know, vehicular manslaughter. 4 years after the adjudication of that, which I think is a Class B felony, that would automatically be erased. Is that the way I'm reading this?
That is correct, sir.
Okay. And I guess the only difference is in the erasure bill that we did. I think it was 12 years post incident.
Right.
It was certainly more. I mean, I don't want to hold you to it.
And I want to thank you for your support in helping us come to a compromise in this section.
Yeah, and I understand the underlying intent, and I thank you for, you know, the back and forth, and you know, it's very serious stuff. I'm just you know, concerned about the extent that this goes to. So you know, I thank you for your, you know, your answer, and you know, in all candor, I started the day, I was going to vote for this, but I have a lot of trouble with that, and I think the public policy that it sends. So I just wanted that out there. So thank you, Mr. Chairman and Madam.
Well, I thank you, sir. But with all due respect, I think what we are trying to do is to address the issues of the actions of the child. It is a child, but it also, after they've learned, they have admitted wrong, and they have gone through the process of being sort of facilitated through the court system and the programs, the mental health programs, etc. They acknowledge at this point in time that they have done wrong, and they are trying to do better. So I think it's looking for rehabilitation of our kids as opposed to retribution. Retribution does not help change the behavior. We're trying to salvage our children and make sure that they get out of the criminal justice system. So I would hope that you would make that, because I think it does allow them to learn. It does allow them to go through the systems and actually understand what they've done wrong and pay their price back to society. But we need to give them an opportunity to survive. So I thank you for that opportunity.
Mr. Chairman, if I may, just briefly.
Yes, absolutely.
Thank you. And I totally recognize all of that. And I'll tell you, since I've become a member of the legislature, that my attitude, my positions in this area have certainly changed. And I think if we were to deal with certain lower crimes, you know, a D or an E felony, that would be a different thing. But we're talking about no restriction. I just think it goes a little far because, you know, the message should be you shouldn't be doing this stuff, and especially these crimes that impact other human beings, lead to death, dismemberment, those kinds of things. So I look forward to the future conversation.
Thank you. Thank you.
Thank you, Representative Fishbein. Representative Anwar. Senator
Thank you.
Anwar, sorry about that.
It's an honor either way. Thank you, Representative Walker, for your detailed explanation. I just, as a chair of the Kids Committee, the Children's Committee, I've started to see the work that the Juvenile Justice Oversight Committee is doing. This is an amazing amount of work. I just wanted to share my gratitude to each and every individual who's involved in this. This is really in-depth work, and as I go through the minutes and the details and the agenda that and the subcommittees that are there, this is amazing work. And I know you're serving in this committee. I know Senator Winfield has been there and Representative Porter. So I wanted to thank each and every one of you because you are part of helping shape the future of children who have been victims of these circumstances in most, if not all cases. And making sure that we are finding a way for them to have a full life and then a safe life going forward. So I, as a legislator who's learning about the work of this committee, I wanted to thank you and everyone who's been working, not only the legislators, but other volunteers who've been working. So thank you so much, and I look forward to supporting this.
Thank you, sir.
Thank you, Senator Anwar. Representative Rabinbis.
Thank you, Mr. Chairman. Mr. Chairman, I also just wanted to echo certainly the importance of the proposal that's before us and all the great work that I know that the JJPOC and certainly Representative Walker and many others, including yourself, have done with this proposal and past proposals as well. I guess, you know, slightly different than what my approach with an earlier bill that came before this committee. I do have still some concerns regarding portions of the proposal that's before us here, specifically one of which I'll highlight, which is the automatic erasure. The automatic erasure, again, as I have read and spoke to many experts, there certainly is a value to having, whether you're an adult or a child, affirm at that time that truly, again, you haven't been rearrested, you're not currently under investigation. And I know there's some language in there, but the automatic action without some kind of affirmation from the individual themselves, I think, you know, unfortunately misses the mark of truly having that rich, you know, remorse for an illegal action that was taking place. And sadly, many of those times, those incidences do have victims. So I do think that that is an important aspect in the literally award of being able to have something erased from your record. And certainly I know that there's a value to the individual. And I think that sometimes this automatic aspect of things, we may be missing the mark for truly what we're trying to do for whether it's a juvenile or an adult in that regard. So I, you know, anticipate and look forward to further discussions on the proposal that's before us. I'm also concerned that we, you know, continue to pass legislation that then does not be taken into action for whatever reason that may be, whether it's financial or simply that it just can't be done. So I'd like to make sure that it's something that could actually, you know, go to fruition, because by passing legislation and finding out year after year that it's either not being complied with, it's not being done, is certainly another frustrating position. So I am going to support the proposal before us, but I do hope and anticipate, as we have in the past, to attempt to work together in order to achieve a product that we all can support. So again, thank you, Mr. Chairman, for the time and opportunity, and I thank everyone who's worked on it.
Thank you, Representative Rabinbis. Representative Howard.
Thank you, Mr. Chairman. If I could, through you to the proponent. The representative, I would love to support this bill. And I think that, first off, I also want to thank you for the hard work that you do to get our juveniles on what I'm going to call the right path. And I 100% stand behind the idea of allowing young people who have made poor decisions, whether their fault or not, to be able to go on from that and go on and lead the great lives that they should. My concern on the erasure is more on a message, and a lot of the things that our children are engaging in, maybe in it, something to society, but it also puts them in dangerous situations as well. And there are people in our state that are adults that are using some of our juveniles to commit crimes for them, and telling our young people in their young minds that whatever you do up until 18, you'll in essence get a reset button on. My fear is that it, I don't want to say encourage, but doesn't do enough to discourage their reckless behavior that could be a danger to themselves, or further incentivize adults who may use that as a crutch to say, go ahead and do this, you're going to be fine because you can start over at 18. Can you answer that for me through you, Mr. Chairman?
Representative Walker.
Thank you, sir, and thank you for the question. We started looking at raising the age because Connecticut was one of 3 states back in the 2000 or 2006, raising the age of adult jurisdiction. We looked at a lot of reasons why we want to do that. And some of the reasons were, one, children under the age of 25 actually do not have complete control over rationalization and understanding. If you think about it, insurance companies or rental company cars, you have to be 25 in order for you to rent a car. There's a reason for that. And as we, a lecturer from I think it was Vassar, or I forgot, one of the colleges Harvard came down and talked to us. No, Dartmouth, I'm sorry. She came down and talked to us, and she said she did an experiment with kids. And she showed them a video of people swimming with sharks. And they asked the kids, would you swim with sharks if you had the opportunity? And the majority of the kids said yes, because they did not understand the dangers of what they're doing, because again, they're too young to understand how to control the rational reasons of why you don't do things. They have to develop it, and they have to develop it with adults standing by their side. We've had kids influenced by adults to steal cars, but we've had kids influenced by adults to do other things too. When they're vulnerable children out there, there's always going to be an adult that's going to try and take advantage of them. And that is not the child's fault. It really isn't. We have to provide those safe mechanisms to help guide them in the appropriate way. So what we try to do, and what we're saying in our programs, is we provide them with those directions and those supports. We provide them with the opportunity to understand and learn what is positive and what is negative, because they haven't gotten that. And then we expect them to acknowledge our platform that we use in our juvenile review boards. The child that does an issue or problem, let's say does a theft or something in their community, they have to acknowledge that they've done wrong. They have to state, I understand what happened. And that's what we are doing. We're trying to give them those supports all over the state through our youth service bureaus and our JRBs, to try and help them learn and grow, to make them good citizens in our community. So what we have to do, once we've gotten them to that point, we have to give them the opportunity, because you know that getting a job with a record is probably one of the most difficult things out there. Being able to get a job that will allow them to be a taxpayer and a part of their community. So we have to provide them with those supports, but we also have to give them the opportunity to be successful. So, I mean, this has got to be developed, and it's got to be grown. and it's got to be supported by us. And we have to go out there and make sure all of our kids have those opportunities.
Thank you, Representative. Representative Howard, you have another question?
I just would like to thank the good representative for her response. In fact, I will tell you, Mr. Chairman, I don't think anything that she said. I actually agree with most of it. I still have my fear that those juvenile minds having no fear of consequence, perhaps. And I agree, once they've committed these acts, that they we can teach them the consequences they haven't been taught before and get them righted. And once we do that, get their record out from underneath them so they can go about their lives now that they've had an opportunity to understand the way that they should be leading those lives. I agree with it. I'm just, my heart of hearts, I'm just afraid of that we may put some of them at risk that aren't at risk now. I'll work on that in my own head. Thank you. I think for.
Thank you, Representative Howard. Representative Fiorello.
Thank you, Mr. Chair, through you. Representative Walker, I wanted to express great gratitude to you for all the work you've done in trying to help children who are vulnerable. And if I may, I wanted to also extend my gratitude to Senator Castor and Senator Flexer for the work they've done on the domestic violence bill to help vulnerable people in difficult relationships. And I wanted to express that I will not be supporting this bill in committee, but I wanted to explain that to say that I am often very concerned about the unintended consequences of bills and a lot of the language that we use in these bills. And I do appreciate that this bill has gone through a lot of vetting, and that you seem to be open also to continue to have vetting on this. And I wanted to share that I just have a very careful approach, maybe because I'm new as well. So that is one of the reasons why I take no votes in committee. The other thing I wanted to ask you was on one bill earlier, we are trying to have consequences for bad actors so that they don't continue to harm people. And in this bill, we are talking about children, so it's very different. But there are people who are being harmed, and I wanted to ask you, Representative Walker, if you were able to hear from and speak to victim groups. And I apologize, I don't really know how they are organized, but are they organized in our state? And were you able to get feedback from them in the portions of your bill?
Yes, we have an Office of Victim Advocate, and they are on our JJPOC committee. And we have had conversations with them about everything. They participate in all our meetings, and yes, they understand exactly what we're trying to do. And thank you for the question. And your statement is that the unintended consequences, I think that goes also with children. We think that children are adults, even though they may be big and look strong and strapping, they're still children, and they still make silly decisions. I know when in my graduate psych program that I went to when I was in graduate school, one of my professors said something that really stuck with me. They said, when you see an 18-year-old, remember the behaviors of a 3-year-old, and you have the same person in front of you, only much larger. And that's the thing that I think we're trying to make people understand. Yes, they're big, yes, they're tall, but they're still developing, and they're still trying to learn how to navigate the society. That's something that we all really need to embrace and look towards helping them do that. So we try to minimize those unintended consequences, but then we also focus on rehabilitation and not casting it so that they never have an opportunity to grow or develop in our society. So thank you for that question.
Through you, Mr. Chair. Thank you for your comments on that. I do agree. I mean, as a mother with a teenage boy, and in today, even the middle of our committee, I had to do something for one of my children, which is why at the moment of the other bill, I couldn't remark with gratitude towards Senator Castor and Senator Flexer. But Rep. Walker, I I know that this bill is very important because we are seeing juvenile crime, particularly in my district as well. And we want to help these kids with a lot of love and affection. And I look forward to seeing this bill be a bill that I can support. But as I explained, and being very careful, I will be voting no in the committee. But thank you, Rep. Walker.
Thank you, madam.
Thank you, Representative Fiorello. Comment or question from other members of the committee? Comment or question? Seeing none, I would ask Madam Administrator if you call the roll.
Leave it in that poll.
Alrighty, that was HB 6667, and that was as amended by JFS proposed sub LCR number 6557. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield was voted in the affirmative. Representative Staffstrom.
Representative Staffstrom votes in the affirmative.
Representative Staffstrom is voted in the affirmative. Senator Castor.
Senator Castor votes yes.
Senator Castor has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Representative Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes no.
Senator Fishbein has voted no. Senator Anwar.
Senator Anwar votes yes.
Could you please repeat?
Sure. Senator Anwar votes yes.
Senator Anwar has voted yes. Senator Bradley. Representative Callahan.
Representative Callahan votes no.
Representative Callahan has voted no. Senator Champagne.
Senator Champagne votes no.
Senator Champagne has voted no. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Could you please repeat?
Representative Dillon votes yes.
Representative Dillon has voted yes. Representative Damassa.
Representative Damassa votes yes.
Representative Damassa has voted yes. Representative Doucette.
Representative Doucette votes yes.
Could you please repeat?
Representative Doucette votes yes.
Perfect. Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes no.
Representative Dubitsky has voted no. Representative Fiorello.
Representative Fiorello votes no.
Representative Fiorello has voted no. Senator Flexer.
Senator Flexer votes yes.
Senator Flexer has voted yes. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Could you please repeat?
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Yes, Representative Godfrey votes yes.
Representative Godfrey has voted yes. Representative Harding.
Representative Harding votes no.
Representative Harding has voted no. Senator Haskell.
Senator Haskell votes yes.
Senator Haskell has voted yes. Representative Howard.
Representative Howard votes no.
Representative Howard has voted no. Representative Labriola.
Representative Labriola votes no.
Representative Labriola has voted no. Senator Lesser.
Senator Lesser votes yes.
Senator Lesser has voted yes. Representative Luxembourg. Representative O'Day. And Representative Palm.
Representative Palm votes yes.
Representative Palm has voted yes. Representative Pavlak D'Amato.
Pavlak D'Amato votes no.
Representative Pavlak D'Amato has voted no. Representative Porter.
Representative Porter votes an enthusiastic affirmative.
Representative Porter votes an enthusiastic affirmative. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis. Oh, here she's coming in the room now. Let me just let her in. Representative Rabimbis, are you connected?
Yes, thank you so much, Madam Clerk. Representative Rabimbis is a yes.
Representative Rabimbis voted yes. Representative Riley.
Representative Riley votes yes.
Representative Riley has voted yes. Senator Sampson. Representative Sims.
Representative Sims votes in the affirmative.
Representative Sims has voted in the affirmative. Representative Veach.
Representative Veach votes no.
Representative Veach has voted no. Representative Walker.
Representative Walker votes in the affirmative.
Representative Walker has voted in the affirmative, and Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Thank you, Madam Administrator. We are now on item number 25, House Bill number 6669, an act concerning juveniles and motor vehicle theft, investigations of certain pending juvenile matters, and reporting of requests to detain arrested individuals. There is substitute language. It is LCO 6544. Is there a motion?
So moved.
Is there a second?
Second.
I believe the motion was by Representative Fishbein and a second by Representative Dubet. Is there discussion?
Hey, Mr. Chair.
Yeah, I'm sorry. Yes, Representative Stafford.
Thank you, Mr. Chair. Mr. Chair, the bill before us does a few things. First, it creates in Section 1, it creates a new crime of enticing a juvenile to commit a crime on one's behalf. The penalty for that would be a Class D felony. In Section 2, it creates new criteria under which a court could determine that a child poses a risk to public safety and to detain that child. That is when they are charged with stealing a firearm or the commission of a violent offense with a deadly weapon. In Section 3, it requires that a child be outfitted with a GPS electronic monitoring device before being released after being caught for their second car theft. In item 4, it increases the criteria for referral to DCF after conviction, and there's a data collection requirement of the judicial branch in Section 5 of the bill. Mr. Chairman, by way of some commentary, I suppose, I understand, and certainly as chair of this committee, I have heard from many members on both sides of the aisle who are understandably concerned with the uptick in car thefts that some communities, and I will emphasize some because it is not uniform across the state, but that some communities in the state have experienced really since the start of the pandemic. I feel I have to just say at the outset that it's important to remember that for the last decade, if you look at statistics, that the rate of motor vehicle theft in Connecticut has been consistently below the national average. And in fact, in 2019, we saw yet another decrease in our rate of car theft, a decrease of almost 19% from the preceding year, which left the rate of car theft overall in Connecticut at about 24% below the national average, actually one of the lowest rates of car theft of any state in the country, quite frankly. Since in 2020, particularly since the start of the pandemic, there undeniably has been a national uptick in car thefts. It has been well reported in national news, and Connecticut has not been immune from that, particularly in some suburban communities. What's actually interesting is the data tends to show that the rate of car thefts in urban communities continues to decrease, but in certain suburban communities continues to increase. We have endeavored over the last several months on this committee to work in a bipartisan way to try to put forward bills that both sides of the aisle care about and members from varying communities care about. Some communities have a view on this, and I assume we'll have a view on this bill that is different from others. But that is the collegial debate that we have on this committee. We exchange those ideas. I hope we can all recognize that the statistics continue to show that over 90% of the car thefts in the state of Connecticut occur when a car is unlocked, and most of those, there's a key fob left in the car. So I would be remiss if I didn't interject a little public service announcement that said, lock your car. We could prevent probably 85 or 90% of the car thefts in the state that way. But with that said, Mr. Chairman, I open up the debate on this bill, by pointing out that, like I said, we have endeavored to try to put forward a bill for discussion on an issue that I know many members are hearing about in certain communities in our state. Thank you, Mr. Chair.
Thank you, Representative Stafford. Representative Fishbaum.
Thank you, Mr. Chairman. I first want to thank the chairs for their negotiations, discussions, many conversations about this bill. A lot of times when we run into bills like this, I think about my grandfather who passed away about 15 years ago, and discussions that we would have. And, I know that if his car had been broken into, that he had left in his driveway, and the response was, "You should have locked the door," he would have been appalled. There was a time in our lives in this country where we didn't lock our doors, quite frankly. I didn't lock my door for many years. Somebody walks in, the answer shouldn't be, well, you should have locked your door. The answer is somewhere else. This bill deals with not just, not the first off property crime. It deals with escalation, which we see all too often. The first incident is a property crime. A motor vehicle is stolen. Many times they see the next time, there's other youths with that individual, and there's a firearm involved. There's been some incidents where, the joyriding, the speeding, and the fancy car, children have died. It's not something that is a good thing at all. So, this bill is not anywhere near what it really started with, but I understand the reality of this situation, working through the legislature and getting something perhaps out of committee. Mr. Chairman, I will point out that Section 1 is something similar to RICO, where I look at the old Oliver Twist with Fagin, getting the children to do his crimes for him, and that's the intent of dealing with those individuals. But I do point out, Mr. Chair, that it appears in subsection B that we haven't made it clear that we're talking about an adult who does these things. And I think it would be appropriate to insert in line 4, after a person, we should insert the clause over the age of 18, so on and so forth, to make it clear that Section 1 is dealing with an adult. And I so move accordingly.
Is there a second to that?
Second amendment, Mr. Chair.
So it's been moved by Representative Fishbaum, seconded by Representative Staffstrom. I would ask, noting who has their hand up already, if there are any people who have a comment or question about the amendment. I don't see any additional hands. So I'll ask Senator Katz, are you just remain maintaining your hand up for the underlying bill? Senator Haskell, that's correct. Representative Gilchrist?
Can he, oh, sorry. Thank you, Mr. Chair. Would he be able to explain the amendment once more?
I will certainly ask the question. Representative Fishbaum, if you could explain the amendment.
Sure, thank you, Mr. Chairman. The intent of Section 1 is to deal with an adult who is using children, juveniles, to perpetrate crimes on behalf of that adult. But the language that's before us is not clear that we're talking about an adult. So therefore, the amendment would be, well, currently it says a person is guilty of enticing, so on and so forth. The amendment would make it a person over the age of 18 is guilty of enticing, so on and so forth. I hope that answers the question.
It does. Thank you. Thank you, Mr. Chair.
Thank you, Representative Gilchrist. Representative Palm, was your hand up for this or the underlying bill?
The underlying bill, sir.
Thank you. Senator Lesser.
Thank you, Mr. Chairman. I appreciate the intent of the amendment, and through you, a question for opponent of the amendment.
You may proceed.
It's my understanding, Representative Fishbein, that the intent of the amendment is to clarify that this section 1 applies to adults who entice minors to commit a crime. I don't see an age gap. Is it possible that an 18-year-old could be incidentally charged under section 1 for associated with a 17-year-old? I think that's a little bit different from the situation I heard you describe in proposing the amendment, that it was intended to attribute to a significantly older person with a minor. And I didn't know if that amendment language clarifies that point or not.
Representative Fishbein.
Mr. Chairman, I didn't totally understand, but I know a portion of that was getting to the intent. And I would just point out that it is the age combined with them knowingly causing, encouraging, soliciting, recruiting, imitating, intimidates, or coerces. So I don't know if that answers the question.
Senator Lesser.
Thank you, Mr. Chairman. And just to clarify, so Representative Fishbein, through you, Mr. Chairman, does not believe that the bill, assuming this amendment goes forward, would allow for an incidental upcharging of an 18-year-old with a felony offense for associating with a 17-year-old, but that intent would have to be established. Through you.
Representative Fishbein.
Yes, use of the word knowingly would mean they have to actively intend to do so.
Senator Lesser.
Thank you, Mr. Chairman.
Representative Stastrom.
Mr. Chair, I would consider this a friendly amendment. It does improve the underlying language here in that, as I read the current language, it could be read to say a 16-year-old could be guilty of enticing a 17-year-old. This would at least clear up that it does have to be someone over the age of 18 enticing someone under that age.
Thank you, Representative Stastrom. I do have a question myself for Representative Fishbein, and I think I made no part of the answer given how we debate the issue of adulthood in this committee. But why aren't we using the age of 21?
Because it is my belief that 18 is the target age. I mean, we hear 18, 21, 25. 18 was the selected age, and I will represent that was the age that was suggested. So,
okay. Comment or question from other members of the committee? Comment or question? I just want to make sure that the individuals whose hand up. I don't see any further, so we will go to. Oh, Representative Bembas, I'm sorry.
Thank you, Mr. Chairman. My apologies that might have been missed. Regarding the proposal that's before us, I just want to thank, obviously, the individuals who have worked on it. I'll anticipate and thank anyone who supports it out of committee. And I think that certainly if further discussions are also necessary to improve this bill in any way, I would imagine that everyone would be open to those discussions. I do think it's very important, and I know that the good Chairman Stafstrom cited some statistics regarding car thefts, comparing, certainly Connecticut over the years and potentially even national. I won't question the chairs regarding the specifics of statistics regarding those car thefts in the sense of the increase of deaths and or injuries and the severity of the property damage, not only to the vehicles, but certainly other property, as these vehicles are continuously, repeatedly stolen by same individuals. I think it's important, and I'm sure everyone has read the proposal that's before us, to highlight the fact that this specifically is for repeat offenders. We are not talking about the one joyride. We are not talking about the one or two or even three potentially, with all of the options that exist currently prior to this proposal coming into place, that people may be stealing vehicles. I do want to call people's attention to the language specifically in the proposal that consistently says subsequent offense, subsequent offense. We already have many diversionary programs, one of which was passed several years ago regarding car thefts. So this would come into play with those individuals who, sadly enough, for one reason or the other, continue to steal vehicles. I think that's a very important aspect here. I also want to highlight that the fact that we are talking about adults who entice children, those are, as we continue to say, the perpetrators who, sadly enough, are leading our youth down the wrong path for a variety of different reasons. One, maybe financial. Two, which we have seen over and over, certainly gang-related crimes. This is a serious concern. So as in many times we even talk about, trafficking, we have to get to the root of the problem. And I think that this proposal does just that. It puts those individuals who are enticing youth to continuously do these bad actions also accountable. I think that's an important aspect of what we have before us in that regard. The other thing too, I want to continue to highlight in this proposal is the fact that it does also request that the court does a deep dive, an investigation as to what exactly is taking place in this child's life that is either forcing, allowing, or enticing the child to continuously do these actions. And I think that the age of 18 is a very important one here as well, because what we're trying to do is to get them while they are young. We want to give them the resources, the opportunity, and the help, while it still makes a difference in their lives early on, as early as possible. And I think that this is one of those proposals that would certainly allow for that. I think the other unique thing in this proposal is also the use of a GPS device. A lot of these, sadly, a lot of these incidences.
I hate to cut you off, but we're still on the amendment. We haven't finished the conversation about the amendment. So you're on a roll, and I hate to cut you off, but I'd like to either adopt or not adopt the amendment and then continue talking about the rest of the bill.
Absolutely, Mr. Chair. I'll be more than happy then to reserve further comments until the amendment is passed.
Thank you. Sorry about that. Representative Porter on the amendment.
Yes, thank you, Mr. Chair. I just want to voice my opposition to the age of 18. We just had a long conversation about, the Representative Walker talked about the age of 25, the prefrontal cortex, the lack of development in order to make sound decisions. And if we're going to do it, I think 21 kind of lands in the middle. It's not 25, it's not 18. So I'm putting 21 on the table. And I just wanted to, make that suggestion. You're on mute. I can't hear you.
Thank you for that. Are you asking for an amendment to the amendment on the table? Is that what I just want to be clear what you're doing here.
Yes, if that is possible. I mean, I'm asking. I don't know if that's something I can do, but we did have a discussion around it. It was my impression that the age would be 21, and for the reasons that I stated, I would be comfortable with 21 since we know it's not going to be acceptable at 25.
Well, that question would go to the proponent, Representative Fishburne, if he would consider it.
Mr. Chairman, as you know, I always consider everything that comes to me. You know, and I respect the overture. The concern here, though, is the crime itself. Now you have somebody who's 20, let's say, who is gathering children, which I envision a gang. Go commit crimes for me. So if the purpose of the raising the age to 21 is to permit that activity, then with all due respect, I don't think that this body on a policy decision should be saying that activity, that gang affiliation, creation, perpetration of rampant crime by a 20-year-old, by a 19-year-old, should be fostered. So I wish we had this discussion yesterday, but here we are.
Me too.
Thank you, Representative Fishbein. Representative Porter, further on the amendment.
Just through you, Mr. Chair, I think that, the point that the good representative just made is a good case point for me. I believe that folks under 25 are still children, and we're classifying them as adults based on age and not the capacity of their brain function. So that was the argument that I was making in order to come to a compromise. And I'll leave it there. Thank you, Mr. Chair.
Thank you, Representative Porter. Anyone else on the amendment? Let me just check, because I don't remember if Representative Palmer, if your hand's been up the whole time or not. Are your underlying bill? Okay. Anyone else on the amendment? Anyone else on the amendment? Then we will cast a voice vote. All in favor signify by saying aye.
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 Nay.
All opposed signify by saying no.
Nay.
Nay.
No.
Abstaining.
Nay.
It's the opinion of the chair that the amendment does pass. On the underlying bill, Representative Palm, your hand was up, followed by Representative Rabimbis. And then I want to ask Representative Porter, is your hand still up, or are you intending to comment at that point on the bill?
My hand is up to comment on the bill. Thank you, Mr.
Okay,
Chair.
so the order will be Representative Palm, Representative Rabimbis, Representative Porter.
Thank you, Mr. Chair. I just want to express my gratitude to everybody who worked on this bill. I've given a great deal of thought, and I will be supporting it. In my district, there have been car thefts, as have there been in many more of the suburban and rural areas. But I do want to say for the record that I think it behooves all of us to be mindful always of the role that poverty plays. And to Chairman Stastrom's point, if there is an uptick that can be traced to the COVID, then I think it behooves us to think about crimes of opportunity and crimes of poverty across the board that exist before they leak into the suburbs, such as gun violence, human trafficking, opioid problems. And they don't often get to be on the radar of some of us until it affects our own district in a more profound way. And so while I will be supporting this bill, I would just ask all of my colleagues to apply the same criteria to crimes that may not affect our own districts as intensely. Thank you.
Thank you, Representative Palm, Representative Rabimbis, followed by Representative Porter, and then Godfrey, and then Dillon. Representative Rabimbis.
Thank you, Mr. Chairman. And thank you again, obviously, for pointing out earlier that we were still on the amendment. And I think I have a sense of, I guess, gratitude and appreciation that it sounds like many fellow colleagues do see the importance of the proposal before us. With that said, I certainly can appreciate that potentially some of these youth may be taking these actions as a result of poverty, but I can assure you that having examined the individuals that are either enticing and or doing, they are not just coming from the cities. They are suburban children. And I think that it's important to recognize, at least in the proposal, the intent that we have in front of us is exactly that, to get to the repeat offenders and allow the court to step out of the traditional punishment role and truly see what is going on so that we could address it. So when we talk about looking at what creates these issues that leads to these children doing this, that's exactly this proposal. And that's why I certainly, feel passionate about it, that I think the intent that we're all trying to achieve, as best as it could be reduced to writing, is the proposal that's before us. Now, Mr. Chairman, I don't know whether or not that this would be allowed, but I'm certainly, I share Representative Fishbine's point that, I wish conversations would have taken place before we're here now, but I also never want to waste a good opportunity. And as much as I truly do believe that 18 is probably the best age here, because if we are getting repeat offenders at the age of 18, I think at the age of 18, more than any other time, we should be then diving into these factors. But I can appreciate Representative Porter's representation of certainly, and I think, we won't dispute that a juvenile's mind of development at the age of 25, that's been out there for studies. And we've heard experts come before us and actually testify to that fact. But I think I certainly want to explore that if there is support for this proposal with the amended age of 21, then I personally would like to see that opportunity taken here. And if it's a joint amendment that Representative Porter would jointly do with myself, if she were to believe that this would gain her support and the support of others. We talk about working in a bipartisan manner all the time. I just don't want to give up that opportunity if we have that here today. So, Mr. Chairman, I don't know exactly how you would like to, I would hate to go through you and address another member of the committee, but I would like to, and I know that Representative Porter is going to be speaking following, but again, in the true belief of working in a bipartisan manner, if this gains support with an amendment to change the age to 21, after having this discussion as at least the intent of why it's at 18, I want to make sure that we can explore that. Thank you, Mr. Chairman.
Thank you, Representative Rabembis. I will just say that if there's ever a time where people can have the conversation that you're asking to have, it's now, not as it sometimes happens in our public hearings. Representative Porter, there's a question on the floor to you, and then you have the floor.
I'm sorry, Mr. Chair, distracted for a moment. What was the question? I know Representative Rabembis was asking.
Either way, I can state the question, or you can restate your question, Representative.
I'd be happy to. So through you, Mr. Chairman, to the good Representative Porter. So my question was that I would be certainly willing to do a joint amendment with you to put the age at the age of 21, if you believe that that would garner your support and potentially others from the committee that may have some hesitation regarding the age that's currently there, which is 18, which, I certainly did state why I believe that the age of 18 is important, because I think that this deep dive, if you're a repeat offender at the age of 18, and the ability to have this deep dive investigation by the court to provide resources and address the main issue, I think certainly is an important one. But going to the point of working in a bipartisan manner and always, trying to reach across party lines and coming to a compromise, I believe that was the word that you used. I don't want to miss that opportunity. So that was my question, very long-winded, but if you believed that an amendment to change the age to 21 here in this committee would garner your support and maybe others, then I would certainly be willing to offer that jointly with you.
Thank you for repeating that, Representative Bimbis. And I would love to see the age go to 21. I would not be supporting the bill because I have several more issues with this bill outside of what we're discussing right now.
Thank you. Thank you, Representative Porter. And having answered the question of Representative Bimbis, you do have the floor.
And this is on the bill, correct? Not the amendment.
Right, no, we have the amendment is attached to the bill. We are now on the bill itself.
Okay, thank you. Well, the only thing that I wanted to state, and it kind of is a segue off of what Representative Palm brought up, I find it really extremely disturbing. And you know, we had this discussion. We have been dealing with this issue in our communities for as long as I've been alive and prior to that. So half a century plus that I can speak of. It doesn't become a problem that we need to do something about in the means of passing laws until it does trickle into our suburban neighbors' communities. And that's really disturbing to me. I want to say that the other thing that bothers me is that, you know, there are Black kids, brown kids, white kids, all kids. This is childhood behavior. So it's not a matter of it just being poor kids that are committing these crimes, because some of these kids are rich, some of them are white. But we know that this country, this state does not, you know, they don't prosecute people the same, right? There are racial disparities in sentencing, in the way we charge people. And if you are poor, you can't afford a lawyer. So now you have to depend on a public defender. And nothing against public defenders, but we know they're all overworked. It's not the same as having a paid attorney. We also know that, you know, the discretion given by judges are doled out differently. The entire justice system, the scales are not equal. And this is what concerns me about us creating a new law within this legislation as well. I would like to deal with the root problem, because this is rooted and grounded in the pandemic. With the uptick, and even with the uptick, Connecticut is still at the lower end of the percentage nationwide when it comes to these car thefts and break-ins. So I will be voting in opposition to this bill. I encourage my colleagues to vote against it, and let's get back to the table and figure out how we help these kids for real, because I don't see this as being an answer to the problem. I actually see it being something that will exacerbate the problem. These kids touch the system once as juveniles. They have a very high percentage rate of ending up in the adult system and in adult prison. And I think the one thing that we said throughout the conversation on juveniles during this committee meeting is that we want to make sure that we are helping these kids and that we are providing them a trajectory out of trouble and into a good life, something that will be positive, not just for them and their families, but for the community and this state as a whole. And I just, yeah, it's a little bit of a bellyache that we've landed here and that we're actually going to do this. And I don't see it as the right thing to do in order to respond to people that I think we need to be educating more about what the root cause is and how we really and effectively deal with what's going on. And I do not see this as the solution. So I just want to put that on the record, and I will be voting no on this bill. And again, I ask my colleagues to vote no as well. Thank you, Mr. Chair.
Thank you, Representative Porter. Representative Godfrey.
Thank you, Mr. Chairman. I appreciate it. A bunch of years ago, I was at a national meeting regarding juvenile justice. I think it was in Oklahoma. And one of the people who were making a presentation on a panel noted that in Oklahoma, they had turned every cop into a truant officer. And if they saw a school-age child out on the street during school days, they'd take the kid to their parents. make their parents actually come into the police station and pick the kid up and explain why the kid wasn't in school. And I actually tried to bring the idea back to Connecticut because in Oklahoma, the number of daytime larcenies dropped precipitously. And I couldn't make it work in Connecticut because Oklahoma had a standardized school year for the entire state and Connecticut doesn't. So there was no practical way to deal with that. But it suggests to me that with the spate of increased larcenies, car thefts in particular, that's a national problem. The problem is kids aren't in school. The solution to me is getting the schools reopened. The solution to me is getting the after-school programs reopened. The solution to me is getting everybody over 16 vaccinated so they can go to school and go to the programs. The solution to me is to develop a vaccine for kids under 16, which I understand is being worked on. There's the real solution. Once everybody's back in school, you're not going to see this kind of behavior happening in Connecticut or anywhere else. It'll all go back to pre-pandemic levels. Now, I like the idea of holding adults responsible for, we use the word enticing, seducing kids into committing crimes, regardless of what the crime is, or otherwise facilitating it. But when that happens, I'm really reluctant to then punish the kid who might be, a mid-teen or something like that. I'm appalled whenever the government starts putting tracking devices on its citizens, regardless of the reason, for something less than a conviction. And the legislation being proposed says put the GPS ankle bracelet on if you've been charged, not if you've been convicted a second time. The libertarian part of me really gets bothered whether it's, traffic cameras, red light cameras, GPS. I viscerally don't like that. So I think there are better ways to go. I kind of like some of the stuff in section 1. The rest of the bill, though, just I cannot swallow. So I feel very strongly I'm going to have to vote no today. Thank you.
Thank you, Representative Godfrey, Representative Gilchrist, followed by Representative Blumenthal, Dillon, in that order.
Thank you, Mr. Chair. I too have many reservations about this legislation. I think there are much better ways to go about addressing this issue. As a state representative from West Hartford, this is a concern in my community. That said, I would agree that, more things can be done, like locking our doors in our driveways. But speaking to the underlying issues, I think that we should, as a state, be investing more in programs like Hartford Communities That Care or Project Longevity, opportunities for youth for after-school programming and things to curb community violence. I too struggle with the ankle devices. I don't like that part of the bill. I also struggle with the age. With all of that said, I will be voting yes to continue this conversation, but reserve the right to vote no at a later date, and hope that we can use this bill as an opportunity to fund community programming that we know can reduce high-risk behaviors and community violence. Thank you, Mr. Chair.
Thank you, Representative Blumenthal.
Thank you, Mr. Chair. I just wanted to discuss my feelings on this bill briefly. First of all, I want to credit you, Mr. Chair, and your co-chair, Representative Staffstrom, for the approach you've taken on this bill. This is a very real concern to some of my colleagues. We've seen an uptick in car theft in my district as well, although, as has been mentioned, we are still in a relatively low period of car theft, both compared to the rest of the nation and compared to past years in the state of Connecticut. And also has been mentioned, nearly all the thefts that took place in my district were from cars that were unlocked and had the key fobs in the vehicle. You know, I'll take this opportunity to speak to everyone out there, whoever's listening, please lock your cars, don't leave your key fob in the vehicle. I blame not just the owners, but car companies who have prioritized, I think, in some ways, ease of access over safety. And we're seeing some of the ramifications of that, not only in the issue of car theft, but the issue of people who've been injured by vehicles that don't properly shut off, because it's not easy to tell whether your vehicle is shut off with some of these new area operated key fob devices. I have some hesitations about this bill. I do appreciate that the chairs have taken a predominantly non-punitive approach and primarily a supervisory approach, introducing more supervision and oversight over some of the individuals who are indicated in repeat offenses of this kind. That being said, I have a number of concerns, including the provision oriented towards electronic monitoring and the age. Like Representative Gilchrist, though, out of respect for my colleagues' concerns and a desire to see this conversation continue going forward, I will be voting yes today. That being said, that does not mean I will be voting yes if this bill comes up on the floor. I think there's still additional work to be done. Thank you, Mr. Chair.
Thank you, Representative. Representative Dillon.
Thank you very much, Mr. Chair. So far as I know, and I shouldn't really say this, there's not a large problem in my own district, although 2 years ago we did have one. And I have some question. I understand, I believe, the sense of violation and fear that people can have, not simply about the car, but about people coming into your backyard or your garage, and I respect that. But I'd like to figure out, through you, Mr. Chairman, to a proponent of this measure, how exactly this would work on the ground. So I have a question. Would it be appropriate to ask Representative Fishburne or Representative Sastrom?
You may frame. Representative Sastrom explained the bill, but I believe that actually I don't even know if Representative Fishburne's Sastrom's currently there, but I think Representative Fishburne can appropriately answer your question.
Yes, thank you, Mr. Chairman.
Thank you. Through you, I appreciated your comment about Oliver Twist, because I was thinking about that myself, and I definitely was thinking about RICO, but maybe differently from the way that you did because of who ended up getting prosecuted under that. I want to understand, in section 1, we create a new crime of enticement. I have concerns about what the standard for that would be, and I'll just leave that there. But the crime is going to be against, with the amendment now, an adult who is influencing younger people, and so that the crime of enticement attaches to an adult. Am I correct?
Yes, you are.
But the ankle bracelets or whatever are going to be attached to the juvenile?
I didn't know, Mr. Chairman, if you want me to wait for your cue or.
You may proceed, Representative.
Okay, thank you. So yes, Representative, it would be the juvenile. However, it is not just on the first offense. It is in the contingency that a juvenile has been already arrested for stealing a car. They are awaiting trial on that first conviction or that first charge. And while during that period of time, they get caught stealing another car and they are released from custody. Upon that release, then that's when the GPS goes into place.
Well, it just seems to me that there's an assertion in the beginning of this language that an adult is influencing others, and yet the remedy later in this language is to track the younger person so that And I'm not going to make the argument that we should put a GPS device on the adult. I'm just saying that it seems disproportionate. Would an adult who is the parent of a juvenile charged under this language?
No, and well, unless they were found to have knowingly caused, encouraged, solicit, recruit, intimidate, or coerce that juvenile to do the crime. And just to be clear, it isn't, section 1 stands alone from the other section. So the adult under section 1, they would be charged in adult court with a felony. So that's a felony under this. This creates that new crime that has really nothing to do with the adjudication of the juvenile that they enticed. So let's say it's the first occasion. So adult says to child, go steal that car for me, right? The adult, if caught, is going to get charged with a felony. The child isn't even going to have the GPS thing because it's the first offense that they're out there for. So the two stand separate, if that answers your question.
Well, given that it's a new crime and we don't know the standard, it wouldn't be astonishing to me if a parent would end up being charged under this language. I'd have to reach a little bit for a fact pattern right now. I can think of a couple of cases from our own area, but they're identifiable. I don't think it would be appropriate. But maybe it's okay if we start charging parents. So I'm not saying that it's not. I feel uncomfortable about this whole area. The GPS is a real issue as well. I mean, and I really think it's overkill. And I believe that the anxiety and the fear are real. And what's happening, I respect that, because I can remember when people in my own area were terrified that hearing statistics about the whole state didn't necessarily persuade them. So I really do respect that people are trying to get at this, but I don't think this works at all. It's the adult, if anything, gets off easy if they're really, a Fagin and they're out recruiting children to commit crimes. And I really think we should be doing more with the children in a very different area. And the GPS thing is just very, very troubling. But thank you very much for your answers.
Thank you.
Thank you, Representative Pavlik D'Amato, followed by Representative Curry.
Thank you, Mr. Chair. I just want to emphasize, in bill after bill that I've heard and discussed and debated on the floor, we always emphasize how important it is not to blame the victim. Yet here, there doesn't seem to be a problem. It's, you should have locked your car. And to me, I think that's insulting. Yeah, lock your car, but at the same time, kids are breaking in and still stealing them. So, if it's unlocked, it's not like most of the time they don't leave the keys in the car, so they're still getting the cars. Again, I don't know when it became acceptable to blame a victim. I shouldn't have to lock my car. It's my car. So, I'm absolutely shocked at that mentality. But again, never surprised. The other point I find surprising is that we are comparing rates from state to state. And yet, I'm off the top of my head, I'm thinking of two different bills, the ghost gun bill, the bump stock bill, had to do with incidents in other states. Yet we had no problem passing those two bills here, even though we didn't have any rates, any incidents specific to that legislation. I mean, at least be consistent, you know, if that's your argument. But again, there's always an exception. And the exception being, you know, since it's being offered and it's trying to, I don't know, stop a crime, that it seems to always be a problem in this committee. And I'm just always shocked at what people have a problem with. I talked to a prosecutor approached me about 4 years ago and had to sit down with me and a couple other representatives about what they knew was coming down the pipe with a bill that we had recently passed, and how she started to see the reaction from juveniles in court and how they knew they would be let go, and so they just do it over and over again. If I'm going to hear that it's not going to work, I'll listen to that from an attorney in court who sees this every day, and that's fine. But other than that, we constantly have in this legislature people saying, whether it's passing, a bill about raises, passing a bill about small businesses, passing a bill about what is going to be effective or not effective in court. It's constantly people who have no experience in the area, deciding this legislation. And I'm just dumbfounded once again at who's an expert in this area and who's not. So thank you for giving me that time, Mr. Chair.
Thank you, Representative Curry.
Thank you, Mr. Chairman. I think before my question, I'm just going to push back a little on the previous speaker. I'm not really sure anybody is really victim shamed. I think our chair has stated statistics and our good vice chair has offered up advice for folks on ways in which to prevent. I'm not sure if anybody has explicitly shamed any of these victims. I know it's a difficult conversation for some to have, and it continues to be a work in progress, and I'm glad to hear that some of the members are going to take care of some of those age things later on. Another thing I might point out is that I believe a car would be considered a dangerous instrument and therefore would trigger an automatic expulsion at the school level. And while that may not be directly linked to this bill and part of another statute that could be updated, I would just ask the proponents to keep that in mind. The last thing we want to do is have these kids moved away from schools where there are programs and services and supports. Definitely not enough, but where they are offered. I do have one quick question though for the proponent. With regards to the GPS, is it true to say that you could potentially have like a 6th or 7th grader walking around their school with an ankle monitor on?
Representative Fishbein.
Yes, and I share your concern. I will say that. And however, that is after the 6 or 7-year-old has stolen their second car and is released from custody. So, the prospects of that happening, and I do share your terror and horror over that. I think the prospects are low. So, but yes, possible.
Representative Curry.
Thank you, Mr. Chair. Yeah, and I appreciate that answer, and obviously in this case, I'm going to echo some of the comments of Representative Porter and highlight, this has been in our community for a while. This just recently happened in East Hartford yesterday. So this is not anything new to us. It's very similar to the opioid crisis, in which many of our towns out on the outskirts were not really keen and aware and ready to offer up their assistance. It's nice to see folks on the front line now on some of these issues. I'm just not sure this is the best way to attack this. So today I will be voting no on. I look forward to the work we're going to do. Thank you, Mr. Chair.
Thank you, Representative Fiorello.
Thank you, Mr. Chair. I'll keep my comments brief. One thing is I really appreciate that this bill is attacking a major important issue, and yet it's only 3 pages long. I often believe that a lot of our bills are too long, and we really want to pass legislation that any normal person can understand. And I feel the words in this bill are pretty understandable. I want to point to lines 47 to 51 that say, such investigation may include an examination of the parentage, surroundings of the child, habits and history, character of the parents and guardians, the mental and physical condition of the child's life there. It even acknowledges that if there's a divorce going on, that you still continue to pursue both parenting, both sides of the guardians. I also like section 5, which says, let's study this, keep the data on it, and report back to the legislature. So overall, I feel that this is a very, this is the kind of bills that I would like to see in general, bills that are short and understandable to the average person. I wanted to make a comment as a mom about the electronically monitored GPS devices. I found with my children that, children like order, and I can think that a child, while he will not enjoy having the GPS device on him, it gives a child a great out to say to the intimidator, the recruiter, intimidator, coercer, that I can't go out, I can't follow you, I've got this GPS device on my leg. And that's just the thought that came to me when I understand the comments around that, but I could also see a different perspective on that. But thank you, Mr. Chair.
Thank you, Representative Fiorello. Representative Doucette.
Thank you, Mr. Chair, and I'll try to keep my comments brief. A lot has already been said. This is an issue that is of a serious concern for my communities that I represent, which is why I will be supporting it today. I've gotten quite a few calls, had quite a few conversations. This is probably one of the top constituent issues over the last few months. That being said, when I have that conversation with folks, I do cite the national trends and some of the other factors that have been discussed. I bristle, frankly, at some of the commentary around this issue in the vein of lock them up and throw away the key. Certainly, that is not what we should be talking about, and I don't believe is what this bill does. That being said, we also still have to continue to move the conversation along. On the monitoring piece of it, I realize that causes me some pause as well, but, and I will point this out, perhaps to the benefit of others on the committee, that I've had many discussions with my chiefs and other officers who cite numerous examples of juvenile offenders being engaged in this activity in day after day. So picked up on a Tuesday and then picked up again on a Wednesday or a Thursday. So I think that's what that is trying to get at. Could that section perhaps be better? And we have some discussions about it. Yes, I would submit. The last thing I'll say is we passed Public Act 19-110 a couple of years ago. One of the things that was in that piece of legislation was some diversionary programs, suspension of proceedings in the interim. And I don't think we have enough information about whether or not those programs have been utilized effectively. I think from my understanding is that due to the pandemic, a lot of those programs have not been able to been utilized. So, but the information we do have from the testimony that was submitted is that they have proven effective. So I would like to continue the conversation as part of this conversation to look at those programs, how they can be more successful and impactful. Again, we'll be supporting this today to move the conversation along. Thank you, Mr. Chair.
Thank you, Representative Doucette. Representative Bembas for the second time.
Thank you, Mr. Chairman, and I appreciate the second time, and I will try to keep it brief. I do want to note that even in a quick Google search, just to provide my fellow colleagues some statistics for Connecticut specifically, the Hartford Courant is reporting, and this was a report done on March 26, 2021, that the number of car thefts reported in Connecticut has rose to a total of 6,200 in 2020. Though they note that the data has not been finalized. So at least we know there's a minimum of 6,200, but there could certainly be a lot more. And apparently that is certainly an increase from a historic low of 2019 that they noted of 5,964. And again, that's from the Hartford Courant. I'm also a little perturbed about the fact that in that quick Google search, we do have what appears to be a teen suspected in Westport car theft dies after a crash. And that is from an article, or actually a reporting of NBC News, Connecticut, February 16, 2021. We also have two East Hartford officers that were injured as a result of a stolen vehicle. And this proposal before us is about repeat offenders. And I want to thank the individuals on this committee for sharing their information, their thoughts on it. And I do hope that this will continue a discussion where it could be something that could be reached in a bipartisan manner. The other thing that this committee has probably heard me say ad nauseum is also advocating for the rights of victims. And although I'm sure not intentionally, when there are references of public service announcements solely around, or the emphasis around that of lock your cars, it really does devalue an individual who essentially has felt violated, even if they mistakenly left it unlocked. And I also want to call your attention that I actually know personally an individual who was loading up her vehicle in her own private driveway. She was being watched, and her items were stolen from the car. And many other people also have their vehicles stolen in that regard. I know individuals at gas stations that have their vehicles unlocked with children in the vehicle whose cars have been stolen. Individuals who get home late at night and have their own vehicles on their private property, exhausted from working multiple jobs, forgets to lock their car doors, and goes into their homes and still has their vehicle stolen, the vehicle that enables them to feed their families. There are real stories. It's not just people leaving their vehicles unlocked because they choose to knowingly. And I appreciate the public service announcement, but at the same time, we continue then to make excuses for bad behavior or stealing the vehicles. So I do look forward to working with all my colleagues. There is an uptick, but I just, again, implore you to understand that these are just not property damage. These are real lives that are being impacted in so many different ways, including deaths. So I think it is important also to empower the victims of this and to say, we're going to take action. We do this for no other victims out there. We don't tell people, well, you shouldn't have been there at that hour. It was a mistake to be there. It was a mistake to do this. It was a mistake to trust. It's just unfortunate that we do hear that with this type of crime because it's not victimless and people do feel violated and people are watching the owners of these vehicles. A strong message, I do believe, needs to be sent out in that regard. And I can appreciate some of the concerns regarding the GPS devices. And I think that, actually most parents might be welcoming of it if they're at work when their children are out and they have no idea what they're doing. And again, repeat offenders. And I think Representative Fiorello did a really good point in saying that hopefully will be also a deterrent for anyone to continue to elicit the same individual to commit these crimes. Thank you, Mr. Chairman, for the opportunity to speak for a second time. And I just encourage all victims of these types of crimes to understand that we are listening, we understand, and we are not blaming. Thank you.
Thank you, Representative Bimbis, Representative Callahan, followed by Representative Veach. And then just a question, Representative Pavlik-Amato, is your hand still up or are you asking to speak again? Oh, okay. Well, Representative Callahan.
Thank you, Mr. Chairman. And I would like to associate my comments with Representative Rabimbus. As I've mentioned in this committee before, I've been a victim 3 times, once of a house burglary, once and twice of car thefts. What that entailed was us changing all of our house locks because we didn't know it was in the car, changing all of our accounts because we didn't know if there happened to be some account verifications or numbers in the car. My wife in tears on the phone with the bank trying to straighten things out. When we recovered one of the cars, it stunk like marijuana and had a theft device that reads key fobs in it. My big question is this, a comment, this is in no way the victim's fault at all. And there's no reason we have video of carloads of teens being dropped off in the neighborhood to go through cars, going deep into people's property. No one has a right to step foot on my property, and those kids are putting themselves in danger in doing so. So I thank Representative Rabimbus for her remarks, and I just don't know what groups of teens are doing at 2 a.m. on a school night. And I wonder, and I do, I agree with Representative Dillon that the parents should bear some responsibility for this. And I'm passionate about this. Our neighborhoods are being hit multiple times, and we have to do something to deter it. And I thank you, Mr. Chairman, for the time to speak.
Thank you, Representative Callahan. Representative Veach.
Yes, to you, Mr. Chair. I just want to mirror some of what Rep. Bimbis and Rep. Callahan have said prior to me speaking. The victims are, they're entitled to some protections. They really, what these children, these juveniles are doing is not okay. The violation is real. It's scary, and it needs to stop, and there needs to be accountability, and there is none. The victims need to be heard as well. Thank you for your time. Thank you. Back to you.
Thank you, Representative Veach. I'm just going to check with Representative Pavlak-D'Amato one more time. Is your hand up to speak a second time, or is it just remaining up? And I'm going to assume Representative Callahan, since you just spoke, that your hand is just still up. Representative Porter, followed by Representative Porter for the second time, followed by Representative O'Day.
Sorry, I was trying to get to my video, and this is real quick. I've been inspired to do a little Googling myself, and I just came across the article that was published on March 19, 2021. New data show car thefts are despite a pandemic fall. And this was an article that was written in the Connecticut Mirror by someone we all know, Pelon Lyons. And I would encourage people to check this out and read it for themselves. But I just want to say that every time we go back and forth like this, there's some very valid concerns being made. And at the end of the day, that this is probably going to pass through the committee. I hope that we have a serious conversation, if that does happen, on restorative justice versus this punitive justice, because the data and the research shows that punitive actually exacerbates crime and makes it worse. It doesn't lower crime in any way or any fashion. This has never been the answer, and it's not the answer today. Thank you, Mr. Chair.
Thank you, Representative. Representative O'Day, followed by Senator Lesser. Well, maybe Senator Lesser.
Thank you very much, Mr. Chair. And I just for an example, and I will read that article cited by my good friend Representative Porter on the overall state numbers. But just for New Canaan, New Canaan in 2016 had 6 car thefts. In 17, they had 13. In 18, they had 10. 19 and 10. And 2020, they had 27. We had 27 car thefts in 2020. So it went 6 in 16, then to 13, then down to 10, 10 and 19, and then up to 27 in 2020. So, that's a big increase. And so going from 6 in 2016 to 27 in 2020, it's a real problem in many of our communities. And I appreciate my colleagues voting for this to get it out of committee. And I'm happy to work with whomever on getting it through the floor of the House and hopefully the Senate. Thank you very much, Mr. Chairman.
Thank you, Representative O'Day. Senator Lesser, followed by Senator Haskell.
Yes, thank you, Mr. Chairman. Mr. Chairman, I'm going to vote for this today. I have some questions about the language of the bill before us, but I think there's no question that this is a significant problem. And even though we can look at numbers across the state over the last several decades, I can tell you flat out that in the district that I represent, many of the towns across central Connecticut, we have seen a significant spike in 2020, or we saw a significant spike in 2020 and into 2021. That merits a response. I think it's important to be thoughtful about that response and to see where the system isn't working. To some extent, there are factors associated with the pandemic that probably came into place. But I certainly agree with those folks on the committee who argue against blaming the victim. People should lock their cars, but if they don't, it's not their fault if the car gets stolen. We need to make sure that, as situations change, we are adapting to respond to contemporary issues. 20 years ago, there were different spikes of car thefts in different areas of the state. And communities work together with the state police to try to tackle that issue in a thoughtful way. And car thefts dropped. And I think we can be thoughtful and figure out how to strengthen tools to address this issue in a way that's appropriate. And I think this bill will has some of that in it, but I think there are additional steps that I think we should consider as well, partly maybe through this committee and also partly through the budget process. Thank you, Mr. Chairman.
Thank you, Senator Lesser. Senator Haskell.
Thank you very much, Mr. Chair. I'll be very brief. I've got a tremendous amount of respect for my colleagues who will be supporting this bill. I'll be voting no, and I just wanted to very briefly explain why. One of the very first things that I did after I was sworn in was visit the Manson Youth Institution, where I know members of this committee are aware young people are incarcerated in Connecticut. And it was honestly really heartbreaking to see students attending school and then returning to a locked cell. I heard from corrections officers that they were frustrated by the system that sends these kids out into the world after their period of incarceration ends without equipping them with the skills they need to succeed. For example, knowing how to drive. These corrections officers knew that too often they would see these kids again, back behind bars, only this time on the adult side. Car thefts are an issue in our community, no doubt about it. And my constituents are as frustrated as anybody. By the way, nearby urban communities have been frustrated by this problem, probably for a much longer time. But our solution cannot be to put more young people behind those bars at Manson Youth Institute. I'm voting no today because I prefer that we lock up our cars before locking up more young people. But I understand the folks who feel strongly the other way, and I respect their decision. I just wanted to explain my no vote.
Thank you, Senator Haskell. I'm going to ask the hands that I see, not you, Senator Haskell, because you just spoke, but Representative, okay, Senator Lesser, you do not want to speak for the second time. Is there anyone else who cares to comment on I've got a lot of jumping around going on my screen. Representative Curry for the second time, followed by Senator Champagne.
Thanks, Mr. Chair. I have a quick question for the proponent with regards to the global positioning system. And I'm going to ask a cost question, and that's typically my biggest pet peeve in committees, that people won't vote for something because of a possible fiscal note. But there's usually language that's included when proposals like this come forward. Who's paying for this? And if they are considered indigent, are they going to have some sort of supports from the state on this, or where do you see that going? Through you, Mr. Chair.
Representative Fishbein.
I believe that presently the courts have a process by which one can waive or be found to be indigent and to have the state pay for it. But for the most part, on programs like this, the individual, I mean, we presently, to my memory at least, don't have this procedure in juvenile court. So I haven't seen it employed there, but I think I have seen it employed in the adult court. So I believe there is a procedure in place by which that could happen if someone is determined to be indigent.
Representative Curry.
I appreciate that answer, and I would just, again, as this moves forward, if this moves forward, I would just ask that that is clarified and made very explicit within language. Thank you, Mr. Chair.
Senator Champagne.
Thank you. Again, I heard somebody say that people should just lock their cars. This is not, anybody that owns a car or owns private property should not be held accountable if somebody walks onto their property, gets into their car, steals it, or steals anything within that car. You know, I ask questions when people come up in front of us, and I've asked several times how difficult it is to go to jail in the state of Connecticut. And they say you got to work very hard at it. It's twice as hard for juveniles to go to jail. We've seen this for many, many years. But sitting here and listening to people say that you know, people should just lock their cars, it's their fault. That's how I heard that. That is not right. Thank you.
Thank you, Senator Champagne. Representative Dillon for the second time.
Thank you very much, Mr. Chairman. I appreciate the discussion today. I'm going to be voting no. I think that some of the concerns that people have are legitimate. We haven't talked about what it's like to be in jail, but I did author about 8 years ago, I don't know, a bill to prevent sexual assault of juveniles in our lockups and correctional facilities. And in the course of researching that, actually learned about our claims commission. And under the previous claims commissioner, they were keeping records on with pencil. I was trying to find out if there had been claims against the state. If you have your car broken into, if it's in your garage, let's say, it feels like an enormous violation, but when that young person goes to prison, that's kind of a lightweight crime, stealing a car. That kind of person is actually a setup for all kinds of assault. And it's been my experience, and I would not hold myself out as more experienced than the other people on this committee. But when I was more involved in it, those kids did not come out better. They came out a lot worse. And so I appreciate the thought that went into narrowing this remedy. I really do. But I don't think it works. And I don't have an answer to how to fix it, but I have to vote no.
Thank you, Representative Dillon. Is a comment or question from other members of the committee? Comment or question? If not, I'm going to end us off. I want to thank everybody for engaging in the conversation, the debate about this proposal. I want to thank the proponents for working to make what I think is a better proposal than some of the things that we initially saw come before us, to be not just reacting in a mode of reacting to the situation, but thinking about the consequences of what the situation is. I want to say that I think sometimes when we have these conversations, we break down along the lines of people who are for and against the victims, and I don't think it's as clear cut as that. I don't want to go too deep into my own background, but I've experienced a life where crime has visited my life many, many times because of the place where I grew up. I would sometimes go to school and the car would be missing. That's just an outgrowth of the neighborhood that I lived in. My home was broken into more times than I could count. I don't think I could count the number of times crimes have happened to me, and we know about the sexual abuse that happened. So I think just because people don't agree with the perspective doesn't mean that they don't understand victims. Sometimes those people have been victims more times than you would care to imagine of crime, and have lived in areas that are rife with crime. But I do think it's important for us to understand that this is really about perspective. And I want to talk about perspective for a second, because there is an important part of this where we talk about what's happened in one area versus another. And what the data seems to be showing us is that there's not just an uptick, right? You could look at that uptick, and if you did the math, you'd see that uptick really does seem to be related to the pandemic. But there's also a shifting of where this is happening, which is what seems to account for why there seems to be so much crime in an individual's area. But they don't care about what's happening in other parts of the state. They care about what's happening in their lives, as we all do. But if you look at the state as a whole, that's what seems to be going on. I don't think we should blame people for leaving the keys in their car, but I do think people should be aware of the circumstances that are around them and think about not leaving keys in their car. And I don't think to say one thing is to say that the people who are having this happen are to blame, because I don't think they are. The commission of the crime is the problem, and there should be consequences. And I think that this committee should think about what those consequences are and what the consequences of the consequences are. That's important to the work that we do, because if what we do by putting in place a consequence, if we don't think deeply enough, causes the number of people who are in our prisons to increase, then we aren't actually safer, because we know what happens when they come back out of our prisons. I hope that everyone thinks deeply about this. I will be a no vote on this, but I'm pretty sure this bill seems to be coming out of the committee. And I hope that the conversation continues, because I don't want to just simply work to stop the bill. I want to see that there's a real conversation around this bill. And with that, I would ask the administrator to call a roll.
Okay, that was 6669, JFS proposed substitute LCO number 6544, along with Amendment A that has passed, offered by Representative Fishbein and seconded by Representative Staffstrom. Senator Winfield.
Senator Winfield in the negative.
Senator Winfield is voted in the negative. Representative Staffstrom. Senator Kasser.
Senator Kasser votes no.
Senator Kasser has voted no. Representative Blumenthal.
Representative Blumenthal votes yes.
Senator Blumenthal has voted yes. Senator Kissel. Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Senator Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes no.
Representative Conley has voted no. Representative Curry.
Representative Curry votes no.
Representative Curry has voted no. Representative Dillon.
Representative Dillon votes no.
Representative Dillon has voted no. Representative DeMassa.
Representative DeMassa votes no.
Representative DeMassa has voted no. Representative Doucette.
Representative Doucette votes yes.
Representative Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Representative Fiorello has voted yes. Senator Flexer. Representative Fox.
Representative Fox votes no.
Representative Fox has voted no. Representative Gilchrist.
Don't mess up.
Representative Gilchrist votes yes.
Representative Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes no.
Representative Godfrey has voted no. Representative Harding. Senator Haskell.
Senator Haskell votes no.
Senator Haskell has voted no. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Could you please repeat?
Representative Labriola votes yes.
Representative Labriola has voted yes. Senator Lesser.
Senator Lesser votes yes.
Senator Lesser votes yes. Representative Luxembourg.
Luxembourg votes no.
Representative Luxembourg has voted no. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day has voted. Representative Palm. Representative Palm votes yes. Representative Palm is voting yes. Representative Pablo D'Amato. Pablo D'Amato votes yes. Representative Pablo D'Amato votes yes. Representative Porter.
Representative Porter votes absolutely no.
Representative Porter has voted no. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbus.
Representative Rabimbus votes yes.
Could you please repeat?
Representative Rabimbus votes yes.
Thank you. Representative Rabimbus has voted yes. Representative Riley.
Representative Riley votes no.
Representative Riley has voted no. Senator Sampson.
Senator Sampson votes yes.
Senator Sampson votes yes. Representative Sims.
Representative Sims votes no.
Representative Sims has voted no. Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Representative Harding votes yes. Did you get that, Madam Administrator?
Could you please repeat?
Yes, Representative Harding votes yes.
Representative Harding has voted yes.
Thank you, Madam Administrator. With that, we are going to stand in recess for 30 minutes. That will be the conclusion of our work for the day. We will be starting at 10 a.m. tomorrow. We have a couple of items that we want to.
Mr. Chair.
Consent.
Yes.
I'm sorry. Yes, I'm sorry. Oh, calm down.
Representative Walker votes in the affirmative. I mean, but negative.
That is right. We do have a consent calendar that we have to call.
I can't hear.
It's gonna echo.
With that, we are going to stand in recess for. Yeah, there's feedback. All right, so we will call the consent calendar. I'm just going to finish what I was saying for your information anyway, since I'm already in the process. We will be in tomorrow at 10 a.m. And we will hope you will be here at 10 a.m. So that we can get some of the work that we have to get done tomorrow done. As you know, it's the last day, so please show up at 10 a.m. Madam Administrator, if you could announce what is on the consent calendar and call the roll.
Certainly. Item number 3, Senate Bill 989, JFS proposed substitute LCO of 6326. Item number 8, House Joint Resolution 75, proposed substitute HJR LCO 6529. Item number 9, House Joint Resolution 78, proposed substitute LCO 6531. Item number 10, House Joint Resolution 103, House Joint Resolution LCO 6487. Item number 11, House Joint Resolution 140, House Joint Resolution LCO number 6493. Item number 13, House Joint Resolution 185, LCO number 6522, proposed substitute. Item number 14, House Joint Resolution 202, that is a House Joint Resolution substitute 6530. Item number 15, House Joint Resolution 211, House Joint Resolution substitute 6547. Item number 16, House Joint Resolution 214, House Joint Resolution substitute 6524. Item number 17, House Joint Resolution 239, House Joint Resolution substitute 6538. Item number 18, House Joint Resolution 264, House Joint Resolution substitute LCO 6534. Item number 19, House Joint Resolution 270, House Joint Resolution number 6542. And item number 20, House Joint Resolution 301, House Joint Resolution substitute 6526.
Thank you, Madam Administrator.
Thank you. Senator Winfield.
Senator Winfield in the affirmative.
Senator Winfield's voted in the affirmative. Representative Stafford.
Representative Staffstrom votes in the affirmative.
Can you please repeat?
Representative Staffstrom votes in the affirmative.
Representative Stafford has voted in the affirmative. Senator Kasser.
Senator Kasser votes yes.
Senator Kasser has voted yes. Representative Blumenthal.
Representative Blumenthal votes yes.
Senator Blumenthal has voted yes. Representative Fishbein.
Representative Fishbein votes yes.
Representative Fishbein has voted yes. Senator Anwar. Senator Bradley. Representative Callahan.
Representative Callahan votes yes.
Representative Callahan has voted yes. Senator Champagne.
Senator Champagne votes yes.
Senator Champagne has voted yes. Representative Conley.
Representative Conley votes yes.
Representative Conley has voted yes. Representative Curry.
Representative Curry votes yes.
Representative Curry has voted yes. Representative Dillon.
Representative Dillon votes yes.
Can you please repeat?
Yes.
Could you please repeat your name? Representative
Dillon, yes.
Thank you. Representative Damassa.
Representative Damassa votes yes.
You'll have to repeat.
Representative Damassa votes yes.
Perfect. Representative Damassa has voted yes. Representative Doucette.
Rep. Doucette votes yes.
Rep. Doucette has voted yes. Representative Dubitsky.
Representative Dubitsky votes yes.
Representative Dubitsky has voted yes. Representative Fiorello.
Representative Fiorello votes yes.
Senator Fiorello has voted yes. Senator Flexer. Representative Fox.
Representative Fox votes yes.
Representative Fox has voted yes. Representative Gilchrist.
Representative Gilchrist votes yes.
Can you please repeat?
Representative Gilchrist votes yes.
Perfect. Representative Gilchrist has voted yes. Representative Godfrey.
Representative Godfrey votes yes.
Please
Did
repeat.
you get that? Representative Godfrey votes yes.
Perfect. Thank you, Representative Godfrey. Representative Harding.
Representative Harding votes yes.
Senator Harding has voted yes. Senator Haskell.
Senator Haskell votes yes.
Can you please repeat?
Yes, Senator Haskell votes yes.
Thank you, Senator Haskell. Representative Howard.
Representative Howard votes yes.
Representative Howard has voted yes. Representative Labriola.
Representative Labriola votes yes.
Senator Labriola has voted yes. Senator Lesser.
Senator Lesser, yes.
Senator Lesser has voted yes. Representative Luxembourg.
Luxembourg, yes.
Representative Luxembourg has voted yes. Representative O'Day.
Representative O'Day votes yes.
Representative O'Day has voted yes. Representative Palm. Representative Palm votes yes. Representative Palm has voted yes. Representative Pablo Tomato.
Pablo Tomato votes yes.
Representative Pablo Tomato has voted yes. Representative Porter.
Forgot to turn the video on. Representative Porter votes yes.
Representative Porter has voted yes. Representative Quinn.
Representative Quinn votes yes.
Representative Quinn has voted yes. Representative Rabimbis. Representative Riley.
Representative Riley votes yes.
Yes.
We can hear you, Representative Rabimbis, but we can't see you. Can you repeat, Representative Rabimbis?
Yeah, I got you.
Okay, I'm going to move on to Senator Sampson.
Okay.
Senator Sampson votes yes.
Could you please repeat?
Yes, ma'am. Senator Sampson votes yes.
Perfect. We got you, Senator Sampson. Thank you. Representative Sims.
Representative Sims votes in the affirmative.
Representative Rabimbis votes yes.
Still not seeing your video, Representative Rabimbis. I'm sorry. Okay, Representative Veach.
Representative Veach votes yes.
Representative Veach has voted yes. Representative Walker.
Representative Walker votes yes.
Representative Walker votes yes. Representative Young.
Representative Young votes yes.
Representative Young has voted yes.
Senator Anwar votes yes. I'm sorry for being late.
That's all right, Senator Anwar. Senator Anwar has voted yes.
Representative Rabimbis votes yes.
Okay, one more time. We can see you now.
Representative Rabimbis votes yes.
Great. Representative Rabimbis has voted yes. Thank you.
Okay. We will be back tomorrow morning at 10 a.m. There is a period of 30 minutes post the end of this, post me calling us to actual recess for people to get their votes in. And we will see you bright and early in the morning. We are going to start right away. I would just ask Senator Sampson, do you have a question? Oh, just ask the ranking member if he has anything to say before we leave.
No, sir. No, sir. Thank you for the opportunity, though.
Okay, so we will stand in recess at 6:20 now until 6:50, at which point the committee will come to a close. The meeting will come to a close. Representative Harding, do you have a question?
No, I apologize, Mr. Chair, just for voting afterwards.
Okay, I'm just trying. I don't want to leave anybody
I
out.
apologize, Mr. Chair.
All right, so with that, with that, we'll be in recess.
Madam Clerk Deb, how do you want to handle this?
Well, we've got a few people here, so let's
Raise your hand.
I think everyone could, what I'll do is I'll start with each vote. And what we'll do is I'll look around the room and call the people that are absent. Does that work for people?
Sure.
Yes.
Yes, Madam Clerk, that works.
Okay, sounds good. Make sure I got everybody in front of me here. All right. Okay, we'll leave the consent calendar last because I got most of everyone from the consent calendar. Okay. Item number 2, 940 was a JF. Let's see. Senator Bradley is still not in the room, I don't believe. Okay. Representative Curry.
Yep. Representative Curry votes yes.
Representative Curry is voting yes. Representative Dillon, are you still around? Okay. Representative Harding. How do you
Representative Harding votes yes.
Representative Harding votes yes. Okay, Senator Lester, are you in the room still?
I am.
Okay, Senator Lester, how do you care to vote on item number 2, 940?
Senator Lester is a yes, and Representative Harding has a very adorable child.
Thank you.
Absolutely. Representative Luxembourg.
Luxembourg votes yes.
Representative Luxembourg votes yes for the baby, for the child.
I'll call you back on, I will, okay.
Representative O'Day.
O'Day votes yes.
Representative
And
O'Day has.
Steve's baby takes after his mother quite clearly.
Thank God she does, Tom.
Representative Porter.
Representative Porter votes in the affirmative.
Representative Porter votes in the affirmative. Senator Sampson, how do you care to vote?
Thank you, Madam Administrator. Senator Sampson votes yes.
Senator Sampson votes yes. You've heard it here first, people. All righty. Item number 4 on the agenda, Senate Bill 1059 that had JFS language LCO 6549. It had an amendment A that has failed. So you can't vote on that because it's already been passed. However, it is JFS language. Okay, so let's see. We need Senator Bradley, who is still not here.
Which bill, Madam Administrator? I'm sorry.
Item number 4 on the agenda, 1059.
Thank you.
You're welcome. Senator Lesser, how do you care to vote?
In the affirmative, Madam.
Could you please repeat?
Senator Lester in the affirmative.
Thank you, Senator Lesser. Representative Luxembourg.
Luxembourg, yes.
Representative Luxembourg has voted yes. Representative O'Day.
O'Day, no.
Okay, O'Day has voted no. Senator Sampson.
Senator Sampson votes no.
Senator Sampson has voted no. Item number 6 on the agenda, 1091, JFS, proposed substitute LCO 6573. Senator Bradley, still not here. Senator Lesser.
Senator Lester in the affirmative.
Senator Lesser has voted in the affirmative. Representative Luxembourg.
Luxembourg votes yes.
Representative Luxembourg is yes. Representative O'Day.
O'Day, yes.
Representative O'Day is a yes. Senator Sampson.
Senator Sampson is a yes.
Senator Sampson is a yes. Item number 7 on the agenda, House Joint Resolution 68, as amended by House Joint Resolution Proposed Substitute 6474. Senator Bradley, Representative Luxembourg,
Luxembourg votes yes.
can you please repeat?
Luxembourg votes yes.
Okay, Representative Luxembourg, got your vote. Representative O'Day,
O'Day votes yes.
could you please repeat?
O'Day votes yes.
There we go. Thank you, Representative O'Day. Senator Sampson.
Senator Sampson votes no.
Senator Sampson voted no. Okay, excellent. Item number 12, House Joint Resolution 175, as amended by House Joint Resolution Proposed Substitute 6541. Representative Luxembourg,
Luxembourg votes yes.
Representative Luxembourg has voted yes. Representative O'Day,
O'Day votes yes.
Representative O'Day has voted yes. Representative Riley, are you still around?
Yes, ma'am. Representative Riley votes yes.
Representative Riley has voted yes.
Thank you.
Thank you. Senator Sampson.
Thank you, Deb. Senator Sampson votes no.
Senator Sampson has voted no. Okay, item number 22, House Bill 6506, the procedures of the Office of the Claims Commissioner as amended by Proposed Substitute LCO 6558 and further amended by Amendment A offered by Representative Fishbein, seconded by Representative Staffstrom, that has already passed as a voice vote, friendly amendment. How would you care to vote? Senator Bradley is still not on the line. Representative Damasa, did you hang around by any chance? Let's see, Representative Damasa. Senator Haskell, you around?
Yes, ma'am. Senator Haskell votes yes.
Thank you. Senator Haskell has voted yes. Representative Luxembourg.
Luxembourg votes yes.
Representative Luxembourg has voted yes. Representative O'Day.
O'Day votes yes.
Senator O'Day has voted yes. And Senator Sampson.
Senator Sampson votes no.
Senator Sampson has voted no. Item number 24 on the agenda, 6667, enact concerning the recommendations of the Juvenile Justice Policy and Oversight Committee, proposed substitute LCO 6557. Representative Luxembourg.
Luxembourg, yes.
Representative Luxembourg has voted yes. Representative O'Day.
O'Day votes no.
Representative O'Day has voted no. Senator Sampson.
Senator Sampson votes no.
Senator Sampson has voted no. Item number 25 on the agenda. 6669, enact concerning juveniles and motor vehicle theft, investigations of certain pending juvenile matters, and reporting of requests to detain arrested juveniles as amended by LCO proposed substitute 6544 with an amendment that has passed, friendly amendment offered by Representative Fishbein, seconded by Representative Staffstrom. The opportunity to vote on that has passed. Senator Anwar, are you still around?
Yes, I am very much around. Thank you. Do you mind if I ask? Well, Senator Anwar votes yes.
Okay, and what would you like to ask?
No, I just will go ahead and vote it. I'm okay. Senator Anwar votes yes.
Okay. All righty. Senator Bradley, are you in yet? I see that you've joined, but can you hear us? Not yet. We'll catch up with him later. Senator Flexer, are you still around? Okay. And that's it. We've got everybody.
Madam Clerk,
Yes.
for that particular amendment, I don't believe I cast my my vote.
Right, because it was a voice vote for all members available at the time, and that opportunity has passed to vote.
Okay, thank you.
Yeah.
Deb, I just want to say thank you for all your hard work. I appreciate it.
Oh, you're welcome. It's my pleasure, Representative O'Day.
Deb?
Thank you.
My second time's comment, Deb. Thank you. Sorry,
Thank
Pat.
you, Representative
That's all right,
Ribindas.
Rosa. I just have one quick question. On 1059, I just wanted to check how I voted.
1059, let's see. 10:59. Where am I at here? You voted no against 10:59.
I did that in error. I was distracted. I meant to vote yes.
You wanted to vote yes. Okay.
Thanks very much, and thanks for all your hard work. Thanks, Zoe.
Thank you. All righty. Oh, Representative Demasa's back. All righty. Representative Demasa, Senator Bradley, I'll be with you in just a moment. I'm just going to, because I think Representative Demasa just has one vote to do.
That's my guy. I always defer to Massa, whatever he wants, man.
Representative
You could have 100
Demasa.
votes in front of me. I would say whatever he wants.
Representative Demasa, are you there? I see you here, but I just want to make sure that you're with us.
You're muted, Mike.
Representative Massa votes yes on that one vote I missed. Thank you, Madam Clerk.
That was 6506. Okay,
Yep.
great.
Thank you. Thank you,
Madam
Senator
Clerk?
Bradley.
Madam Clerk, I just want to check real quick my vote on 6549. That was the LCO for solitary confinement. I want to make sure I got that right.
Okay. Solitary confinement.
Hey, Bradley.
59.
Representative Porter, you my guy. You could have 1 billion votes in front of me, and I just chill right here. Not a problem.
And you look like you chilling too.
I am.
Representative Porter, you voted affirmatively on 1059.
And I'm good to go, right?
Yep.
All right. Thank you so much. I love you. Thank you for the work you do.
It's our pleasure. It's a team effort. Okay, Senator Bradley. Let's start with this. Okay. Senator Bradley, the consent calendar. Did you want me to go down the list of everything that's on the consent calendar?
Yeah, not necessary. Senator Bradley votes in the affirmative.
Okay, Senator Bradley's affirmative on the consent calendar. All righty. Now, on the actual bills that we voted on, item number 2, 940 AF. That's, want me to read you the title?
Go ahead. I'm sorry. It was just outside traffic. I apologize, but go ahead, Deb.
Okay, 940 was a JF and that concerning state agency compliance with probate court orders. How do you care
Senator
to
Bradley
vote?
votes in the affirmative.
Senator Bradley has voted in the affirmative. Okay. Item number 4, 1059, and that concerning the Correction on Accountability Commission, the Office of the Correction Ombuds, the use of isolated confinement, seclusion, and restraints, social contacts for incarcerated persons, and training and workers' compensation benefits for correctional officers. And this is JFS, proposed substitute LCO 6549 as amended. Note that amendment A has failed. Okay. How do you care to vote, Senator Bradley?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Okay. Item number 6, 1091, and that concerning a study of criminal laws of the state as amended by JFS 6573, which turned into, that's the DV bill. Senator Bradley, how do you care to vote?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Item number 7, HJ68, resolution granting the Claims Commissioner an extension of time to dispose of the claim of Hard v. Atcherson, proposed substitute, so it's the JFS, HJR LCO 6474. Senator Bradley, how do you care to vote?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Item number 12, House Joint Resolution 175, resolution granting the Claims Commissioner extension of time to dispose of the claim of Brian Jefferson as substituted by LCO 6541. Senator Bradley, how do you care to vote?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Item number 22, House Bill 6506, and that concerning the procedures of the Office of the Claims Commissioner as amended by JFS, proposed substitute LCO 6558, and further amended by a friendly amendment by Representative Fishbein, seconded by Representative Safstrom, and that was passed on a voice vote, passed with voice vote. Senator Bradley, how do you care on the bill, underlying bill?
Nothing like kumbaya moments with our fellow Republicans. Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Okay. Item number 24, 6667, and that concerning the recommendations of the Juvenile Justice Policy and Oversight Committee, JFS proposed substitute LCO 6557. Senator Bradley, how do you care to vote?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative. Item number 25, 6669, and that concerning juveniles and motor vehicle theft, investigations of certain pending juvenile matters, and reporting of requests to detain arrested juveniles. There was an amendment A that passed. It's a voice vote offered by Representative Fishbein, seconded by Representative Staffstrom. How would you care to vote, Senator Bradley?
Senator Bradley votes in the affirmative.
Senator Bradley has voted in the affirmative, and that concludes our business with you today. Thank you, Senator.
Debbie, thank you so much.
Thank you. We'll see you
Zoe,
tomorrow.
thank you as well. Have a good day. Have a good day, ladies. Bye-bye.
Madam Administrator?
Hello, Senator Flexer. How are you? Would you like me, Senator Flexer, to read off the items on the consent calendar?
No, I know what's on the consent calendar, Madam Administrator. I believe I only missed 2 votes.
Okay, you missed the consent calendar. So how do you vote on
I'd
the
like to vote yes on the consent calendar.
Can you say Senator Flexer?
Oh, Senator Flexer votes yes on the consent calendar.
Thank you, Senator Flexer, for voting yes on the consent calendar. Let's see what else we missed.
I believe it was just the second to the last bill.
Okay, double check while we got you here. You can't get your back ones just on you. There we go. Item number 25 is the last bill, and that concerning juveniles and motor vehicle theft investigations of certain pending juvenile matters and request to detain arrested individuals is amended by 6544 and further amended by Amendment A. Vote, Senator Flexer.
Senator Flexer votes no.
Senator Flexer has voted no.
Thank you very much.
Thank you.
Did Representative Walker vote on the car theft? There was like something, it was really wonky at the end.
Representative Walker voted no on the car theft bill. Yeah. Okay. What time is it? Oh, it's moments.
I can do all the votes.
God, oh, you got enough things to do. I started putting the record action, so I'm on a roll here.
You want to give me the last couple? Do you want to give me?
Go save yourself. Tomorrow we'll be needing your help.
No, it's okay. Do you want to give me 22, 24, and 25?
Hold on, I'm putting right I'm in now. Yeah, we've got everyone's voted, so the only thing at this point would be somebody would change their vote.
Yeah, I texted Steve. I know that he missed one
Right.
vote. Yeah, if you want to send me those 3, I'll do those.
Okay. I'm just putting in the action right now. It's about 50-50 as if it's taking the LCO number. Oh, that one took.
Do you want to send me pictures or do you just want to scan it to me really quick?
Oh, that's true. I'm in the office. I can do that. It's probably a lot faster.
just like watching you guys work. So I gotta thank you both. A lot of hard work. This really sucks. I didn't say that.
We're live on YouTube, Representative Fishbein.
The what?
We're still live on YouTube.
I know. Yeah, I know. Where are we? Well, okay.
Where are we?
I see Zoe over there counting votes, so I know what she's counting. So where are we?
Would you like me to text you?
Yeah, please. Okay. Thank you. Talk to you. Bye.
You're all set. Oh, he's gone. He's all set. Okay. So we're just waiting for Steve on this one, but yeah, if you don't mind sending that to Zoe. Yeah. Okay, the last three new ones.
Yeah.
Yeah, and make sure you don't even put NO in the thing. They said we could put, well, I'll do the consent calendar.
You can't write number. You just
No.
put in.
No, you just could LCO and the number. You can't put NO, you can't put hashtag, you can't put anything. We're moving on. But they said next year they'll fix it so that we can do what we've been doing. So that's good. That's helpful. These are connected, and these two are connected, and that was.
Yeah.
Okay. Thank you, Alan.
Okay, he scanned it to me.
Yeah, he scanned you the last one.
Okay, cool.
Oh, and there's Steve.
Yep.
Hey, Steve. Just asking him to unmute.
Hey, can you hear me?
I can hear you now. Yep. So
Okay.
This is the last one, number 25, 6669. So you don't want me to go through all the mushigas of what it is.
No, Representative Stafford votes no.
Representative Stafford has voted no. Okay.
Thanks.
Thank you. Okay, so just added that Zoe to 25.
Yeah.
Okay, perfect. Excellent. Thank you.
And that's being scanned to me?
Yeah.
Okay, cool. Thank you.
Okay, so you're gonna handle these. Nope, because I'm gonna do the rest. I'm gonna. So now that you know how to do. So you're getting yellow.
Well, I tried to do the other one. I got really yellow. Don't ask me how. Now let's just keep going.
The loop of fame. Could you put in these actions? You know what? That's a lot. Here, just double check that these have been these actions have been entered. I think I pretty much did them all, but I don't know where I left off.
Where do you go to check to see if the actions are in?
You have to go there and see if,
I put in the bill number.
put in the bill number, and then you put get actions and see what the last row looks like.
I don't have any row. Oh, you gotta add a row and then.
Well, don't add a row if it's already got the row. I'm not laughing at you. I'm laughing. I just couldn't see your screen. I just know, I'm sure it's not working.
Yeah. Right, so you do get actions.
And then when it brings out the bill, then you look and see like the date and the last action that was showing up. Like if it's just showing public hearing, then you know you got to add it in. But if it shows today's date and there's an action on it, well, that's not good. Why'd you put a date? Put an action in there. I'm not laughing at you, Alan. It's just laughing at the whole incredulity of the whole fun. And Zoe, could you mind printing those to the printer here, or will that mess you up?
No, I can print it.
Yeah, because we're making copies of all the vote tally sheets for the 5 folder.
Oh, okay. Okay. What just happened? And I'm coming in tomorrow, by the way.
Thank you. Yeah, it'll be Alan and George will be back. Alan just says if we leave.
I have papers all over my living room floor, like all over.
Oh God.
Probably, what would be nice if some brainchild in IT would put the damn bill numbers to the left so you know what it was.
You know, you got to keep hopping over like this. Yeah.
I mean, the old way, yeah, the bill number showed up.
Showed up, right? I think right above it or something.
Yeah.
I think, Mm-hmm. Oh yeah.
These are in, I didn't check to see if LCO numbers were in.
Yeah.
God knows who we don't get that.
Well, see, before you used to see that.
Yeah, they still are all once. Yeah, control A. How do I call it?
Okay.
Do you want these back or I throw them out?
Yeah, I'll take them. Oh God.
what's next?
Oh, what next is, you know what I'm gonna do is once I get these once I get these actions in, well, you know what, I'll give you the rest of these to do. It's got a lot of proposed substitute. What I'm gonna do is once I get the vote tallies, then if you can check them,
All right.
you know. Start packing up your troubles. Oh, it's 6:50. Hold on, let me just. Alan, that's the best line of the day. Oh goodness. Oh Lord, Nevin. Oh God, help us. Okay, it is now 6:50. The JUD Committee meeting for Thursday, April 8th is now concluded. We'll see you in the morning at